Hello, 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 sound check. Hello, hello, check. Hello, 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 1 2 3 check. Hello, 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 sound check. Hello, hello, check. Hello, hello.
Good evening, all of you. See, yesterday we were very slow, okay. So, we had exhaustive deliberation over the course of speed yesterday, okay. Few basic points. I will be available after the class, okay. Uh, any question that you have related to prelims, okay. There can be a factual statement. I usually go through the newspaper and important aspects, okay. But I'm also a human being. I may not have read the newspaper, although I keep reading throughout the year. So maybe possible there is a factual element. So then also I'll get back to you, okay, if there is any such thing. Otherwise, 99% of the time, if you will come up with a factual question, any question, you can ask any question which is related to UPSC, first thing. Second thing, those questions which are, for example, very subjective in nature, okay, which are very subjective in nature, which have multiple interpretations and factual, those things we will not debate. Get it? Because what do you mean by right, what do you mean by liberty, what do you mean by secularism is not something that is, you're getting my point, that is what you call, that can be debated, because they have multiple aspects. I'll show you one important thing, then we'll start the discussion today. Just a second. More comfortable in PC format, okay. So yesterday we were running short of time. Two students asked very good question. One question was asked on right to contest election. Okay, so we were running short of time. One student asked, and second one more question related to right to contest election. Okay. A petitioner moved Supreme Court 2 years back that he want to contest Raj Sabha elections even without a proposer. Okay, because right to contest election is a right. Okay, so the Supreme Court in this judgment said कि सुनिए, first of all, you don't have a fundamental right to what you call contest election. There is no such thing. Supreme Court says it is not even a I'm just quoting the judgment. It is not even a common law right. It is not even a common. What is a common law right? When we studied in our law college, we used to study common law all the time. What is common law? In United Kingdom, there is no written constitution, and mostly things are based on conventions or ordinary laws. So that set of law that has evolved from the judgment is called as common law. जैसे many things have come in India from an interpretation of the constitution. जैसे for example, Armed Forces Special Power Act 11 September 1958. Armed Forces Special Power Act Section 2 empowers the central government, administrator of a union territory or governor of a state. Explicitly, central government, administrator of a union territory or governor of a state to declare any area as a disturbed area. To declare any area as a disturbed area. सो इसमें सुप्रीम कोर्ट ने नागा पीपल्स मूवमेंट फॉर ह्यूमन राइट्स केस में कहा कि दिस सेक्शन कैनॉट बी कॉन्स्ट्रूड, दिस सेक्शन कैनॉट बी इंटरप्रेटेड टू गिव पावर टू द गवर्नमेंट टू इम्पोज अ डिस्टर्ब्ड एरिया फॉर indefinite period. It has to be reviewed before the expiry of 6 months period. Getting my point? In the law, there is no time frame limited. It is written, central government, administrator of a union territory or governor of a state can declare an area as a disturbed area. This was said by, this is written in the law. But Supreme Court in Naga People's Movement for Human Rights case interpreted and read that act cannot be construed as giving an indefinite power to declare an area as disturbed area without any time limit. It must be reviewed every 6 months. Now this is not written in the law. This is not written in the constitution. So this is an example of a origination from a common law. Now one thing I want you to see, because in your batch we are, the Supreme Court, this I have shown in some batches and yours also I just want to show because I was working on yours so that we can make this session very, very productive. Okay. Yesterday we were going very slow. Now dear students, for Supreme Court judgment summaries. Okay, summaries. So Supreme Court has started an initiative, Center for Research and Planning. Now they themselves give you the summary of the major constitutional amendments. Okay, so I know there are many, we usually don't mention private sites, but some sites which are constantly mentioned by the scholars, even in the debates of the parliament, like SC Observer, which is a very good venue to find the Supreme Court judgment. Now, Supreme Court themselves have started this initiative, that they will give, जैसे 2025 में there is no constitutional bench judgment yet, so 24. May they give the summaries, just they give all the judgments that you heard in 2024 related to Madarsa Act. One, related to Madarsa Act. Second, you studied about all the judgments, Aligarh Muslim University law, everything is mentioned over here. Okay, so one thing I will say, then I'll move ahead. A judgment was delivered by the Supreme Court, a judgment was delivered by the Supreme Court on the validity of UP Madarsa Act. So UP Madarsa Act was declared as unconstitutional by Allahabad High Court, and Supreme Court overturned the judgment. And Supreme Court said no law can be declared as unconstitutional for violation of basic structure of the Constitution. Next day, in all the prominent newspapers, Hindu, Indian Express and all, there was a thing ki bhai, laws cannot be declared unconstitutional for violation of basic structure. So many students came to me, sir, basic structure has been overruled by the Supreme Court. ऐसा नहीं है. What Supreme Court said कि terms like secularism, federalism, rule of law, democracy, these terms are open-ended and vague terms. We cannot declare law as unconstitutional for undefined concepts. Otherwise, every law directly or indirectly will end up violation of secularism, democracy. So laws can only be declared as unconstitutional when they violate a particular provision of the Constitution. For undefined, I am exactly quoting from the judgment, from undefined concepts like secularism, democracy, laws cannot be declared as unconstitutional. So there was a widespread confusion. Supreme Court has not said that we will not respect basic structure of the Constitution. Supreme Court has said undefined concepts like secularism and democracy are open-ended terms. You cannot go on declaring laws as unconstitutional for this. Now, if you see here, this Madarsa Act, just one line, this is the original website of Supreme Court. Supreme Court said that court ruled that concepts such as democracy, federalism and secularism are undefined concepts, and allowing courts to strike down laws for violation of such concept will lead to uncertainty. The Supreme Court held that Madarsa Act and all those things is a thing. Okay, so this is something which I don't want to go further into this. Center for Research and Planning. So for judgments, you can first find over the Supreme Court website only. Now coming back to the question. Related to right to contest election, this can be a prelim statement. Right to contest election, ab gaur se suniye. Isme two important things are there. First is related to Rajya Sabha, other is related to what you call Section 62, subsection 5 of Representation of People Act 1951 says that anyone who is in jail will not have the right to vote. Only one exception is there, that is preventive detention. Now this was also challenged along with the fact that they want to contest the election. Ab isme what the Supreme Court said. Supreme Court, isse bhi important ek case hai, I'll go 10 years back. एक केस था जन चौकीदार, where पटना हाई कोर्ट ने रूल किया कि if a person is not allowed to vote, how can he be allowed to contest election? अगर वो वोट नहीं कर सकता है तो इलेक्शन भी नहीं लड़ सकता. But we know that if he is not disqualified under section 8, subsection 1, 2, 3 and 4 was declared as unconstitutional, we don't, you know, Lily Thomas case. So next day the Union government moved Supreme Court, because if the judgment of Patna High Court will virtually put a full stop that any person who is in jail will not contest the election, which will lead to right way or not. Why? Whether the money that was available was spent in the way it was meant to be. So do you think 543 members of Lok Sabha and 245 members of Raj Sabha, they do not have time, they do not have the logistic support, they do not have the academic expertise, they do not have such long what you call single capacity to. So for that, to assist the parliament, you have created the office of Comptroller and Auditor General. अब कैग में क्या होगा? आर्टिकल 148 ऑफ द कॉन्स्टिट्यूशन, इसमें होंगे आप लोग, इंडियन ऑडिट एंड अकाउंट सर्विसेज, एंड गवर्नमेंट ऑफ इंडिया कैन नॉट ट्रांसफर यू, यू कैन ओनली बी ट्रांसफर्ड बाय कैग, बिकॉज कैग इज द हेड ऑफ इंडियन ऑडिट एंड अकाउंट सर्विस. पार्लियामेंट के बिहाफ पे, बिकॉज पार्लियामेंट इज नॉट हैविंग टाइम, सो यू स्पेशल सर्विस बनाई गई है, यू विल ऑडिट द अकाउंट ऑफ ministers and then you will present the report to the then and the report will be tabled in the parliament, and then these reports will be studied by public account committee. So CAG जो है, CAG को कहा जाता है, CAG is the friend, philosopher and guide of public account committee, and CAG will audit the account of the ministries on the behalf of the parliament. For example, ministers say कि we have not done any corruption, we are correct. So people will say, how can you say that? Will say, you ask CAG. So the fiscal accountability of the executive towards the legislature is established by the reports of CAG, and he is an independent officer. He is removed in the manner similar to that of Supreme Court judge. For example, father gave you 1 lakh rupees to spend money. Okay. So father later on asked you that have you spent the money in the right way? If you will yourself say yeah, then it is no accountability because you have spent the money. You will say I have given all the records to the mother and she has verified the records, and father will confirm yes, you have verified. So the fiscal responsibility of you towards your father is established by the reports of the mother, where she has gone through the records and she says that you have correct. So CAG audits the account of the executive on the behalf of the legislature, और CAG को कोई नहीं डरा सकता है because he is removed in the manner similar to that of Supreme Court judge. अब उन reports को पेश किया जाएगा पार्लियामेंट में. These reports are studied by पब्लिक अकाउंट कमिटी. समझ गए? और पब्लिक अकाउंट कमिटी में ऑपोजिशन के कोई मेंबर होंगे. बाय कन्वेंशन ही विल बी द चेयर person. So usually when I was in college, BJP was in opposition. Murli Manohar Joshi ji was the chairman of Public Account Committee. When Congress came in opposition, then you have Adhir Ranjan Chaudhary ji and KK Venugopal ji. Opposition का जो सबसे important चेहरा होगा, he is the chairman of Public Account Committee. So Public Account Committee will study the reports of CAG, which has audited the accounts of the ministries, and then हाँ एक major criticism है कि अब पछतावत से क्या होगा जब चिड़िया चुग गई खेत. So already the expenditure has been made, so just they conduct a post-mortem. Now going back to our topic, now listen, 3 report CAG prepare करते हैं. Report on appropriation account, report on finance account and report on public undertaking. Appropriation और finance account की जो report है वो study करती है committee on पब्लिक अकाउंट्स कमिटी, और रिपोर्ट ऑन पब्लिक अंडरटेकिंग वो स्टडी करती है कमिटी ऑन पब्लिक अंडर. आई एम अगेन सेइंग 3 रिपोर्ट्स आर प्रिपेयर्ड बाय कैग. रिपोर्ट ऑन फाइनेंस अकाउंट, रिपोर्ट ऑन एप्रोप्रिएशन अकाउंट एंड रिपोर्ट ऑन पब्लिक अंडरटेकिंग. रिपोर्ट ऑन फाइनेंस अकाउंट एंड एप्रोप्रिएशन अकाउंट्स आर स्टडीड बाय द पब्लिक अकाउंट कमिटी, एंड रिपोर्ट ऑन पब्लिक अंडरटेकिंग इज स्टडीड बाय कमिटी ऑन public undertaking. And estimates committee is what we call it that this is the continuous economy committee. All 30 members are from Lok Sabha. Now come here. So DRSCs 24 है. Honestly कहें तो after budget the role of DRSCs, getting my point, they will study the bills, they are advisory. Public Account Committee and Estimates Committee function, although these committees also function, but PSC function throughout the year. These are also important. अब other committees. अब dear student, other committee में important है Estimates Committee, बिल्कुल important है. Last year I said आ रहा है, आ भी गया. Okay. So ये Ethics Committee, sorry, not Estimates Committee, Ethics Committee. You have Privileges Committee, Committee on Women Empowerment, Committee on SC/ST, Committee on Subordinate Legislation, Committee on Private Members Bill, from Libraries Committee to Committee on Women Empowerment, from Committee on SC/ST to Business Advisory Committee. There are many committees which come under the category of other committees. पर आप सब नहीं पढ़ सकते हैं. All you cannot study. But yes, if they will ask committee on first ethics committee, which I said they have already asked. Second, privileges committee. ये दो brutally important है. Third, committee on private members bill. Committee on private members bill. Fourth, committee on subordinate legislation. Fifth, you study the business advisory committee, although that is not an important. Or then you have committee on women empowerment, क्योंकि women issues are going on. So women empowerment. एक और अगर पढ़ना चाहते हैं तो committee on SC/ST welfare. They studies the report of National Commission for Scheduled Caste and National Commission for Scheduled Tribe. So these are the important. जिसमें most important, if you will ask me, I will say ethics committee and privileges committee, but now I will not say, because already they have asked. I said last year also, and they already asked the ethics committee in 2020. मैंने बोला था कि ethics committee और delimitation दो question I said कि वो पूछेंगे इस बार, and probably they asked this question. This year if you will see, I am saying more likelihood of not these permanent committees, but इनसे हटकर, ये सब तो हो गई परमानेंट कमिटी, इससे हटकर टेम्पो रेडी कमिटी, जहां ज्वाइंट पार्लियामेंट्री कमिटी ऑन वक्फ, ज्वाइंट पार्लियामेंट्री कमिटी ऑन व्हाट यू कॉल वन नेशन वन इलेक्शन, इस पे दे कैन आस्क अ क्वेश्चन ऑन दिस. परमानेंट कमिटीज में अगर कहें तो एवरग्रीन इंपॉर्टेंट है पब्लिक अकाउंट कमिटी. मेंस में भी पूछा है, प्रीलिम्स में भी पूछा है, मेंस में भी पूछा है, प्रीलिम घुमा घुमा के दे आस्किंग. एस्टिमेट्स कमिटी, कमिटी ऑन पब्लिक अंडरटेकिंग आल्सो दे कैन. अदर कमिटीज में एथिक्स कमिटी, प्रिविलेजेस कमिटी, विमेन एम्पावरमेंट, एससी एसटी, सबऑर्डिनेट लेजिस्लेशन, प्राइवेट मेंबर्स बिल, इससे क्वेश्चन पूछ सकते हैं. सो डियर स्टूडेंट, द मोमेंट इन मेंस मोस्ट इंपॉर्टेंट इज डीआरएससी. क्यों भाई, क्यों डीआरएससी इंपॉर्टेंट है? थ्रू आउट द ईयर दे गिव सम और द अदर सजेशंस. जैसे आई विल गिव यू एन एग्जांपल. I'll give you an example कि छोड़िए अभी उस पर टाइम नहीं जाएंगे, छोड़िए. Now, so please understand, for mains department related standing committee in December 2022 current affairs of Vision IS, you will find recommendations for CBI given by department related standing committee. So one thing that you need to remember on this particular thing, कि from prelims point of view you should have an idea. अब उसमें कुछ small facts है, एक काम बस कीजिएगा, don't only read Lakshmikant, also go to the website of the Parliament. All these committees are mentioned over there. If you will study from them, then there is almost जितनी भी चीजें मैंने बताई है गलत होने के chances ही नहीं है. There is no, because you are reading from the primary source. Hardly it will take half an hour. That is why I say कि there is always a time crunch. There is always a time. It is not tough, but the syllabus is relatively more voluminous. And see, the point is of late prelims थोड़ा tricky हो गया है. So all these things, otherwise तो Lakshmikant and it's over. Okay, थोड़ा सा current affairs mix कर दिया. So the point is कि you have parliamentary committees. So if we start from the basic ad hoc committees, then we have permanent committees में DRSC and 3 financial committees and other committees. So there is a world, but still I will emphasize on privileges committee, ethics committee, committee on women, committee on what you call subordinate legislation and private members bill. You go through these committees. Few important things they can ask in prelims. सबसे पहले all the committees have what you call this thing, have a advisory role. ठीक है. So all the, in fact पूरे constitution और पूरे statute में, पूरे कॉन्स्टिट्यूशन में सिर्फ एक ही बॉडी मुझे लगी जो सरकार से कुछ भी करवा सकती है. देयर इज ओनली वन बॉडी विच कैन मेक एनीथिंग फॉर द, इफ यू नॉट इट, दीज थिंग्स आर नॉट रिटन इन द कॉन्स्टिट्यूशन. फ्रॉम द इंटरप्रिटेशन ऑफ द कॉन्स्टिट्यूशन देयर इज ओनली वन बॉडी, दैट इज आर्टिकल 324 इलेक्शन कमीशन ऑफ इंडिया. वरना आर्टिकल 338 शेड्यूल कास्ट कमीशन, 338A शेड्यूल ट्राइब, 338B बैकवर्ड क्लासेस, 350B स्पेशल ऑफिसर फॉर लिंग्विस्टिक माइनॉरिटीज. यू हैव द आर्टिकल 344 ऑफिशियल लैंग्वेजेस कमिटी. कितनी भी इन सब all of them are advisory in nature. Article 315 UPSC में एक थोड़ा सा है कि one ministry of the government cannot reject the recommendation of UPSC. It has to be rejected by entire cabinet and you have to inform the parliament why the recommendations of UPSC were rejected. So they have certain safeguard. Otherwise all of them are advisory in nature. सिर्फ ECI ऐसा है जो सरकार से कुछ भी. In 1990s Rajya Sabha elections were meant to be announced. One person was a minister, a very dignified, respectable member. Election Commission said, until you give us all the powers, we will not notify the Rajya Sabha election. So that particular minister has to resign because he has to get elected as a member of Rajya Sabha within 6 months. After Supreme Court directed the ECI, they were given all the powers. Then elections were conducted. Second time he took oath again. So Election Commission of India can do anything under the sun for. Otherwise, I have not seen a single commission which Protection of Human Rights Act 1993 Human Rights Commission के recommendations को government उसके भी limitations हैं. They can look into human rights violation of last 1 year. They cannot investigate the human rights violation by the members of armed forces. They can seek a report from the center. Their recommendations are not binding in nature. Only you have to inform the parliament reasons for non-acceptance. But Election Commission of India can do anything for free and fair elections. Otherwise, they will stop the election. One committee which I want to mention, which is my guess for this year, that is Article 344 of the Constitution and Official Languages Act 1963. दोनों में mention है. That is Committee on Special Committee on Official Languages. This is mentioned. This is the only parliamentary committee that is मेंशन्ड इन द ये सिर्फ एक पार्लियामेंट्री कमेटी हमारे संविधान में मेंशन है. नो पार्लियामेंट्री कमिटी इज मेंशन्ड इन आवर कॉन्स्टिट्यूशन एक्सेप्ट द पार्लियामेंट्री कमिटी ऑन ऑफिशियल लैंग्वेजेस. इसमें 20 मेंबर हैं लोकसभा के, 10 मेंबर हैं राज्यसभा के. रीड आर्टिकल 344 ऑफ द कॉन्स्टिट्यूशन. इस कमिटी का काम क्या है? व्हाट इज द मैंडेट ऑफ दिस कमिटी? देयर इज एन ऑफिशियल लैंग्वेज कमीशन. ऑफिशियल लैंग्वेज कमीशन हैविंग रिप्रेजेंटेशन फ्रॉम ऑल लैंग्वेजेस इन 8th शेड्यूल. इस कमीशन के रिपोर्ट को स्टडी करने के लिए, टू स्टडी द रिपोर्ट ऑफ दिस कमीशन, देयर इज अ कमिटी कॉल्ड एज कमिटी ऑन ऑफिशियल लैंग्वेजेस, एंड ऑल दीज लैंग्वेज मैटर कम्स अंडर मिनिस्ट्री ऑफ होम affairs. Okay, so committee on official language is only parliamentary committee that is mentioned in the constitution, article 344. इसमें 20 मेंबर लोकसभा के होते हैं, 10 members, 20 from Lok Sabha, 10 from Raj Sabha. This is the only parliamentary. They can ask this year. If you'll ask me, official language committee, I feel they can ask, or temporary committee. इससे sudden surprise दे सकते हैं क्योंकि they have not asked. 3 committees which speaker is the ex officio chairman, business advisory committee, rules committee and general purpose committee. Okay, I'll go to the थोड़ा स्लो है पर we'll manage. Okay, this इसमें तो they are asking a question. Committees में if you will give to disproportionate access, if you will give 2 hours to committee, that will be helpful. एक question आएगा ही, prelims में आएगा. Most likely they will ask a question in prelims. I have given you the parliament chapter. Background से they have already asked a question, not that important this year other than delimitation. Parliamentary officers और parliamentary devices, इससे एक question बनता है. एंड पार्लियामेंट्री कमिटीज बजट से दे विल आस्क एन इजी, वही अप्रोप्रिएशन फाइनेंस घुमा रहे हैं. ओके, दोस थिंग्स दे विल आस्क. बस इफ यू डू दिस ओनली इन देन डेफिनेटली. now this is recently Lok Sabha moved motion to form public account, so it means appointed, elected by the house, all these things, article 105. ad hoc committees and permanent committees, permanent का example दिया हुआ है. पब्लिक अकाउंट कमेटी का दिया हुआ है 22 मेंबर्स, एस्टिमेट्स कमेटी 30 मेंबर्स. दिस इज पार्लियामेंट्री कमेटी ऑन ऑफिशियल लैंग्वेजेस. दिस इज सेक्शन 4 में भी मेंशन है, एंड दे हैव नॉट मेंशन्ड हियर. इट इज आल्सो मेंशन्ड इन आर्टिकल 344 ऑफ द कॉन्स्टिट्यूशन. उसमें भी आपको मिलेगा ऑफ ए कमिटी ऑन ऑफिशियल लैंग्वेजेस. दिस इज आल्सो मेंशन्ड देयर. नाउ दिस क्वेश्चन वाज आज प्रिविलेजेस कमिटी. यू विल गो थ्रू दिस. हाँ, कैबिनेट कमिटीज. कैबिनेट कमिटीज यू नो, कैबिनेट कमिटी के भी आने के चांसेस हैं. कैबिनेट कमिटीज आर नॉट पार्लियामेंट्री committees. I think we should give some more time to this. Okay, just now you see here, सबसे first thing that you should know, cabinet committees are not parliamentary committees. सबसे बड़ा reason 2 है. What is a parliamentary committee? ओके, ये इफ यू विल ओपन लक्ष्मीकांत, उसमें एक चैप्टर है देयर इज अ चैप्टर पार्लियामेंट्री कमिटीज. उसमें फर्स्ट पैराग्राफ में लिखा हुआ है व्हाट इज अ पार्लियामेंट्री कमिटी. वो यहीं से लिया है, यहीं से. they have you just go and see, they have taken from the primary source. Actually they have done a good thing. This is the official website of sansad.in bracket ये ls मतलब लोक सभा. So क्या वो किसी भी कमिटी को we cannot call a parliamentary committee. A committee will be a parliamentary committee if it meets all the following criteria. So in Lakshmikant you will find parliamentary committee a chapter, and they have said what is a parliamentary committee. What is a parliamentary committee? If it meets all the 4 criteria laid down in the this. All 4 criteria they have taken from the official website of the parliament. क्या है भाई? यहाँ से शुरू होता है. A parliamentary committee means a committee which is appointed or elected by the house or nominated by the speaker. First point वहां दिया हुआ है, स्लैश करके लिखा है chairman, because this is the website of Lok Sabha, so they have written speaker, you will write chairman. First point. Second point, works under the direction of speaker slash chairman. Second point. Third, presents its report to the house or to the speaker slash chairman, because this is the website of Lok Sabha. And fourth, secretarial assistant is provided by Lok Sabha Secretariat or Raj Sabha. So every committee is not a Article 243 ZD, District Planning Committee. Getting my point? Part 9A of the Constitution, Metropolitan Committee. Every committee is not a part. Justice Fazl Ali Committee, LN Jha Committee से लेकर what you call Vijay Tendulkar से लेके हजारों committees हैं. But every committee is not a parliament. A committee is a parliamentary committee if it will meet all the ऑल द फॉलोइंग क्राइटेरिया, देन इट इज अ। अब सुनिए, कैबिनेट कमिटीज होती हैं, ऑल्दो दिस इज एन ओल्ड डॉक्यूमेंट दैट, बट ठीक है। कैबिनेट कमिटीज आर कॉन्स्टिट्यूटेड अंडर गवर्नमेंट ऑफ इंडिया ट्रांजैक्शन ऑफ बिजनेस रूल्स 1961, पहला। दूसरा, what do the cabinet committees do? They reduce the enormous workload of the cabinet. जैसे फॉर एग्जाम्पल, गौर से सुनिए, उधमपुर श्रीनगर बारामूला रेल प्रोजेक्ट that is going to connect Srinagar to New Delhi from now Jammu and all those things you hear every day. So the point is, this is a bigger project, thousands and thousands of crore rupees. So cabinet meets only for once in a week or after 15 days, and they too for 2 hours. So they have limited time. So cabinet committee on economic affairs will first study the project, and they will do everything. Just a mere stamp of approval by the cabinet. So cabinet committees function on the principle of division of labor. Either the prime minister is the chairman of a cabinet committee, या तो खुद प्राइम मिनिस्टर चेयरमैन होते हैं या सीनियर कैबिनेट मिनिस्टर। दो ही ऐसी कैबिनेट कमिटी है उसमें प्राइम मिनिस्टर इज नॉट द चेयरमैन। फर्स्ट इज कमिटी ऑन अकोमोडेशन, अमित चंद शाह जी इज द चेयरमैन, एंड पार्लियामेंट्री अफेयर्स राजनाथ सिंह जी इज द चेयरमैन। अदरवाइज ऑल द पार्लियामेंट्री ये कैबिनेट कमिटीज आर हेडेड बाय द प्राइम मिनिस्टर। कैबिनेट कमिटीज फंक्शन ऑन द प्रिंसिपल ऑफ डिवीजन ऑफ लेबर। वो करते क्या है, वो कैबिनेट के वर्कलोड को बहुत रिड्यूस कर देते हैं, रिड्यूस द इनॉर्मस वर्कलोड ऑफ द कैबिनेट। सो दिस इज, अब इसमें कौन है, कैबिनेट कमिटी ऑन अपॉइंटमेंट। जितने भी इंडिया में अपॉइंटमेंट होते हैं, फ्रॉम द गवर्नर टू द CAPF BSF डायरेक्टर, SSB डायरेक्टर, ITBP डायरेक्टर, रॉ डायरेक्टर, IB डायरेक्टर, गवर्नर, जितने भी आपका इंटर कार्डर डेप्यूटेशन वो तो छोड़िए, इफ यू विल मैरी आउटसाइड योर कार्डर यू विल चेंज, दैट विल ऑल्सो बी अप्रूव बाय द appointment committee of cabinet. This is one of the most powerful committees when it comes to appointment. जितने भी इंडिया में appointment होते हैं, it is approved by the, every third day you will read newspaper, appointment committee on cabinet approved cabinet secretary, appointment committee of cabinet joint secretary empanelment. Just from today onwards you go and read Hindu and Indian Express, every fourth day you will see an approval has come from appointment committee of cabinet. One IAS officer from Jharkhand cadre sent on inter cadre deputation to JK, approval by appointment committee of cabinet. You are in Bihar cadre, you will marry someone and go to Maharashtra cadre, approval by appointment committee of cabinet. After years of service you are appointed as director general CISF, approved by, so jitne bhi appointments hote hain they are appointed by appointment committee of cabinet, and only two people are there, home minister and prime minister. Very very powerful committee. Okay, uske baad cabinet committee on accommodation related issues, theek hai, important hai. Cabinet committee on economic affairs, cabinet committee on parliamentary affairs. This was 2019, they have been reconstituted, so go and check, you will find on internet, although members UPSC will not ask. Cabinet committee on security, India's nuclear doctrine says that any decision on nuclear will be taken by cabinet committee on security. इसमें 4 ex officio members होते हैं, home, defense, external affairs, and you have what you call finance and prime minister, headed by prime minister, or 4 cabinet ministers are ex officio members of cabinet committee on security, home, defense, finance and external affairs. So you have defense, external, home, external affairs and finance and prime minister. India's nuclear doctrine में cabinet committee on security takes all the decision on nuclear. ये दो कमिटी लास्ट में बनी है 2019 लोकसभा इलेक्शन के बाद, कैबिनेट कमिटी ऑन इन्वेस्टमेंट एंड ग्रोथ, कैबिनेट कमिटी ऑन एम्प्लॉयमेंट एंड स्किल डेवलपमेंट. व्हाई दीज कैबिनेट कमिटीज आर? सबसे पहला अंतर, difference between a parliamentary committee and cabinet committee. First, parliamentary committees have members of parliament. Usually cabinet ministers are not allowed to become a member of a parliamentary committee. Cabinet committees are usually headed by prime minister. Cabinet ministers are also only members, but yes, there is no prohibition. Minister of state can also become member, but very very rarely. Minister of state are permanent invitees, but they are not members. They may become member. So पहला difference हुआ here, members of parliament वहाँ sitting minister, पहला. दूसरा, कैबिनेट कमिटीज आर कॉन्स्टिट्यूटेड अंडर गवर्नमेंट ऑफ इंडिया ट्रांजैक्शन ऑफ बिजनेस रूल्स, यानी प्योरली एग्जीक्यूटिव कमिटी. पार्लियामेंट्री कमिटीज आर कॉन्स्टिट्यूटेड अंडर द रूल्स, स्टैट्यूट और द प्रोविजंस ऑफ द कॉन्स्टिट्यूशन, सो इट इज कॉन्स्टिट्यूटेड बाय द लेजिस्लेचर. सेकेंड इंपॉर्टेंट थिंग. थर्ड इंपॉर्टेंट थिंग, कैबिनेट कमिटीज का काम है टू रिड्यूस द वर्कलोड ऑफ द कैबिनेट. पार्लियामेंट्री कमिटीज का काम है बहुत to the work done by the parliament is not only voluminous in not only complex in nature but also considerable in volume. The work done by the parliament is not only what you call this thing complex in nature but also considerable in volume. A great deal of parliamentary work is done by these parliamentary committees. Very simple. Okay, this sometimes it hangs. Okay, now if we see here, ये लिखा हुआ, द वर्क डन बाय पार्लियामेंट इज नॉट ओनली कॉम्प्लेक्स इन नेचर बट ऑल्सो कंसिडरेबल इन volume. The time at its disposal is limited, therefore it cannot give close scrutiny to all the legislative and other matters. A good deal of parliamentary business is performed by parliamentary committees. So जैसे घर में when you prepare what you call anything, palak paneer, okay, or chili paneer, or you prepare chicken or whatever, you ask the person who is helping you, you chop the onions, you make everything, you will just go and cook. That is what cabinet committees do. They reduce the workload of the cabinet. It is merely a matter of formality that cabinet will put a stamp or a thing which has already been discussed and finalized in a cabinet committee. Why? Because there also the prime minister is the head, and here the cabinet is also headed by the prime minister. चूंकि ये बात चली है, without wasting much time, एक और important concept you are missing: central secretariat versus cabinet secretariat. Just 2 minutes. You see in Delhi Metro, yellow line है ना, Delhi University वाली, yellow line में you will have central secretariat. So if you will make an exit from central secretariat metro station and you will say कि take me to central secretariat, वो confuse हो जाएगा. There is no one building as central. Please understand the difference between central secretariat and cabinet secretariat. सारी ministries और departments को मिलाकर central secretariat is a colloquial term for all the ministries and departments. If you make an exit from central secretariat metro station and you will say take me to central secretariat, he will kill you, because there is no building as central. It is Ministry of Railways, Shastri Bhavan, then you have what you call Krishi Bhavan. Getting my point? Sab milakar banta hai, all the ministries and department collectively are called as central secretariat, but there is one building that can be called as cabinet secretariat. Cabinet secretariat का 4-5 काम है. 1, to assist the prime minister in his cabinet related responsibilities, to prepare an agenda for the meeting, note down what was discussed in the meeting, any decision has to be communicated to all the ministries, and most importantly, ye cabinets, I also didn't knew, one of the cabinet secretaries was explaining on internet, cabinet secretariat serves as the most important, although I know the articles of the constitution, but practically he said that cabinet secretariat is next to Rashtrapati Bhavan. Reason being, cabinet secretariat serves as a link between the council of ministers and the Rashtrapati. Kyun? Because article 53, all executive actions of the union are taken in the name of President. Article, all executive power of the union shall be vested in the President. Article 53. Article 77 clause 1, all executive actions of the union are expressed to have been taken in the name of President. चूंकि President के नाम से सारा काम हो रहा है, everything is done in the name of President. So cabinet secretariat keeps the President informed about the matters of the union, about the administration of the affairs, so serves as a link between the executive and the president. So cabinet secretariat का काम है cabinet related, okay, and cabinet secretary is the chairman of civil services board. हाँ, पूरी जितनी ministries और department है सबको मिला के बनता है central secretariat, and inside the ministry you have, जैसे ministry of finance, उसमें department of economic affairs, department of expenditure, department of revenue, department of investment and public asset management, department of financial services, and department of public enterprises. Getting my point? So these are the 6 department under ministry of फाइनेंस. सो एक मिनिस्ट्री के अंदर डिपार्टमेंट्स होते हैं एंड डिपार्टमेंट्स, एंड देयर आर मिनिस्ट्री. हाँ, डिपार्टमेंट ऑफ एटॉमिक एनर्जी एंड स्पेस डू नॉट फॉल अंडर एनी ministry, and ministry of external affairs do not have departments, they have divisions. So central secretariat matlab it is the totality of all the ministries and departments, while cabinet secretariat is one body that is responsible for cabinet related function. If you will say to the cab wala that drop you at cabinet secretariat, he will drop you at cabinet secretariat, which is one building. But if you'll ask him to drop you at central secretariat, all the ministries and departments collectively are called as, he will immediately ask you want to go to Rail Bhavan or Shastri Bhavan, क्योंकि central secretariat is a colloquial term for all the ministries and departments. अब you understood between the cabinet secretary and the parliamentary government. Now secretariat of parliament, this is an easy chapter. कि the constitution of India empowers both the houses of parliament to have their secretariat. So there is a Raj Sabha secretariat and there is a Lok Sabha secretariat. Just to add, every year they come with vacancies. For past many years I am seeing mostly जो उसमें recruit होता है, almost everyone who is recruited is preparing for civil services. So usually civil services वाले apply करते हैं. उसमें 2-3 पोस्ट होती है. एक होती है प्रोटोकॉल ऑफिसर which is a good post, दूसरी प्रोटोकॉल असिस्टेंट relatively थोड़ा है. बस 2-3 एडवांटेज है. You will be posted in Delhi for your entire life. Salary and all is purely part of legislature, so कोई गवर्नमेंट से आपका लेना देना नहीं है, पूरा इंडिपेंडेंट है. एंड थर्ड, यू विल ट्रैवल अलॉट विद द मेंबर्स ऑफ पार्लियामेंट. सो मोस्टली उसमें इंग्लिश पूछते हैं, ज्यादा इंग्लिश का टफ रहता है, एक मतलब कैट टाइप का इंग्लिश थोड़ा. सो यूजुअली दोनों का रिक्रूटमेंट होता है, लोकसभा सेक्रेटेरिएट का भी और राज्यसभा. मोस्टली आई हैव सीन लोकसभा सेक्रेटेरिएट, राज्यसभा सेक्रेटेरिएट में ऑल द पीपल आर देयर, ईदर दे आर प्रिपेयरिंग फॉर सिविल सर्विसेज और दे आर दोज पीपल हु यूज्ड टू प्रिपेयर फॉर सिविल सर्विसेज एंड दे हैव एग्जॉस्टेड देयर अटेम्प्ट्स. उनका अलग से एग्जाम होता है. दोनों का अपना सेक्रेटेरिएट है. आर्टिकल 98 अलाउ करता है और स्टेट के लिए आर्टिकल 187. ओके, सो पहले उनका नाम था काउंसिल ऑफ स्टेट सेक्रेटेरिएट एंड लोकसभा सेक्रेटेरिएट. नाउ नेम हैज बीन चेंज. ओके, सर्विसेज होते हैं ऑल द. इसमें एक हिंदू में आर्टिकल आया था. What article was given in Hindu that secretary, abhi recently you read one week back, the tenure of पता नहीं, मुझे ये नहीं समझ में आता. I literally feel I read the same newspaper but you don't read. मुझे दूसरा हिंदू देता है, दूसरा न्यूज़पेपर देता है. I am shocked. The tenure of the Rajya Sabha secretary chairman was extended. Okay, so ये this can also be a question कि राज्यसभा सेक्रेटेरिएट के चेयरमैन एंड लोकसभा सेक्रेटेरिएट के चेयरमैन आईएएस ऑफिसर्स होते हैं, कभी आईआरएस भी है, एक आईआरएस ऑफिसर है. बट डिमांड है कि द स्नेहलता मैम थी, स्नेहलता वर्मा, शी वाज द चेयरमैन सेक्रेटरी ऑफ लोकसभा सेक्रेटेरिएट, शी वाज फ्रॉम द लोकसभा सर्विसेज. सो देयर इज अ डिमांड दैट समबडी फ्रॉम लोकसभा सेक्रेटेरिएट शुड बी मेड chairman, secretary general of Lok Sabha and secretary general of Rajya Sabha. Why? Because they 30-40 years of their life, 35 years they do for the parliament, so they have better understanding of the working of the parliament. But usually secretary general general of Lok Sabha and secretary general of Rajya Sabha is somebody who is an IAS or group A officer. Every fifth day in Hindu you will read an article by PDT Acharya. PDT Acharya, just go and see. कुछ भी इशू होगा PDT आचार्य का आर्टिकल जरूर आएगा. He was the Secretary General of Lok Sabha when we were student. Okay, now he writes articles because he has an understanding and knack of the constitution. कोई भी लोकसभा में इशू होता है उनका आर्टिकल जरूर आएगा हिंदू में. That is PDT आचार्य, वो भी सेक्रेटरी जनरल थे लोकसभा के. Okay, जैसे in a ministry you have minister and you have a secretary. Similarly, in the Lok Sabha you have speaker and secretary general of Lok Sabha, and Rajya Sabha you have chairman and secretary general of Rajya Sabha. All the work is done by secretary general of Lok Sabha and Rajya Sabha under the overall guidance of speaker and chairman. ये officer है और वो political authority है, क्योंकि speaker doesn't have time, he will preside and multiple things, so it is done by. So Lok Sabha secretariat administrative head होंगे secretary general, और यहाँ भी administrative head होंगे secretary general, ऊपर होंगे chairman and स्पीकर. अब इसमें डिमांड है कि सेक्रेटरी जनरल, मोस्ट ऑफ द सेक्रेटरी जनरल जो हुए वो आईएएस या आईएएस या इस तरह के ऑफिसर्स हुए हैं. देयर इज अ डिमांड दैट लोकसभा सेक्रेटेरिएट सर्विस से पीपल शुड बी मेड बिकॉज दे हैव बेटर अंडरस्टैंडिंग ऑफ द फंक्शनिंग ऑफ द लोक सभा. सो यू हैव लोकसभा सेक्रेटरी. नाउ दिस इज कैबिनेट सेक्रेटरी. 2017 प्रीलिम्स में क्वेश्चन आया था. प्राइम मिनिस्टर इज द चेयरमैन ऑफ सिविल सर्विसेज बोर्ड, विच वॉज अ रॉन्ग स्टेटमेंट बिकॉज कैबिनेट सेक्रेटरी इज द चेयरमैन ऑफ सिविल सर्विसेज बोर्ड. टाइम मिले तो ऑर्डर ऑफ प्रेसिडेंस देख लीजिएगा. गूगल पे यू जस्ट टाइप, आई डोंट हैव टाइम अदरवाइज आई हैव शोड यू एवरीथिंग. गूगल पे यू विल टाइप ऑर्डर ऑफ प्रेसिडेंस मिनिस्ट्री ऑफ होम अफेयर्स. ये क्वेश्चन कभी कभी इन द वर्स्ट ऑफ डेज दे विल आस्क इन प्रीलिम्स, एंड इफ दे आस्क अ क्वेश्चन मोस्ट ऑफ द टाइम ऑल ऑफ यू विल मेक अ मिस्टेक इफ यू हैव नॉट गॉन थ्रू द सेम. कि इंडिया में जो ऑफिशियल प्रोग्राम में किसकी ऑर्डर ऑफ प्रेसिडेंस में कौन है. ऑफकोर्स प्रेसिडेंट, वाइस प्रेसिडेंट अप टू 5 यू नो, बट दे विल ट्रैप यू बियॉन्ड दैट. ओके, सो व्हाट इज द पोजीशन ऑफ ऑर्डर ऑफ प्रेसिडेंस मिनिस्ट्री ऑफ होम अफेयर्स का पीडीएफ देख लीजिएगा. नाउ कैबिनेट सेक्रेटरी अपॉइंटमेंट कमिटी ऑफ कैबिनेट ने अपॉइंट किया है. रिस्पॉन्सिबल फॉर एडमिनिस्ट्रेशन गवर्नमेंट ऑफ इंडिया एलोकेशन ऑफ बिजनेस रूल्स. अब ये किस आर्टिकल के तहत है? दीज रूल्स आर मेड अंडर आर्टिकल 77 क्लॉज 3. ओके, दिस इज देयर इंटरमिनिस्ट्रियल एक्स ऑफिशियो चेयरमैन ऑफ सिविल सर्विसेज बोर्ड एंड नो अथॉरिटी ओवर वर्किंग डिपार्टमेंट्स. मतलब इट्स प्राइमस इंटर पेयर्स, मतलब जितने भी सेक्रेटरी हैं, कैबिनेट सेक्रेटरी इज ऑल्सो अमंग देम बट फर्स्ट अमंग द इक्वल्स. जैसे चीफ जस्टिस ऑफ इंडिया इज फर्स्ट अमंग द इक्वल्स, जैसे प्राइम मिनिस्टर इज फर्स्ट अमंग द इक्वल्स. ओके, then this question is very very important. This has been asked many. Under article 86 of the constitution, president can send messages to both the houses of parliament. Under article 87 of the constitution, president addresses both the houses of parliament on 2 occasions. कौन सा 2 occasion है? You must have seen that. You have seen ना? Okay, so president addresses both the houses of parliament on 2 occasions. ये question इतनी बार आया है, many a time they have asked this question. Okay, So okay, now you have what you call, for example, the Honorable President of India addresses both the houses of parliament, ceremonial, okay, or is
delivering to India's doorstep in 10 minutes.
so this is the Honorable President of India addresses Meri Sarkar, the Honorable President would say. So under Article 87 of the Constitution, it is a why this question can be asked, dear students, because in Tamil Nadu, two instances the Honorable Governor have walked out from the assembly. We are not into the political nature, but what you understand, the Constitution of India mandates that on two occasions compulsorily the president will address both the houses of parliament. इन दो मौकों पे president दोनों house को address करेंगे. पहला, the first session of every year. So 2025 has started. First session will be budget session, so president will address. दूसरा, whenever a new Lok Sabha comes to life, after every 5 year, जब भी एक नई लोक सभा आती है उसका जो फर्स्ट सेशन होता है उसको एड्रेस करते हैं प्रेसिडेंट. This is Article 87 of the Constitution. Article 86 more likely to be asked because 87 has been asked 15 times, but 86 has not been asked. Under Article 86, President can send messages to both the houses of Parliament related to bills. So on two occasions, the President addresses, and similarly you have for the Governor. Now I will show you this particular thing. That the President addresses joint sitting of the Parliament after the formation. Article 86 allows the President to address the House. President has not so far addressed under this provision. Conventionally, Article 87, first session of after Lok Sabha, first session of every year. So, अब इसमें क्या होता है? Originally, President to both the House at the commencement of every session. This was amended. पहले था before every session. Now only first session of every. क्यों? From UPSC perspective, President addresses both the houses of parliament at the beginning of every year. This is an SSC question. Why the president addresses this? I don't have time, but always remember this is the opportunity where the president will not speak anything other than what has been approved by the cabinet. So the speech of the president is approved by the cabinet. Since childhood I have heard this speech. The president will say many times my government, because under Article 74, under Article 75, the Prime Minister and the Council of Ministers are appointed by the president. ये speech क्या होती है? Whatever the present government is achieved till now and what they want to achieve, this is an annual opportunity where the government, through the mouth of the Honorable President of India, let the people of the country know what are the future roads ahead for the government. So this is a very important speech on governance, because this gives a broad framework and guideline as to what the government is expected to do in the next year and what the government has achieved in all these years. All the entire speech for last 50 years, you will see the Honorable President will keep repeating my government. Why? Because ये वो स्पीच है जिसके जरिए, I'll speak in Hindi then in English, ये वो स्पीच है जिसके जरिए गवर्नमेंट अपनी सारी जो उसकी रोड मैप है वो लोगों के सामने प्रस्तुत करती है. दिस इज अ स्पीच वेयर द गवर्नमेंट प्रेजेंट्स द रोड मैप बिफोर द पीपल एट लार्ज. सो अंडर वन थिंग, after this is written in the rules that after the presidential address there will be no discussion, nothing will be, so उसके बाद उसमें नहीं होता है, then there will be vote on thanks. Getting my? So motion of thanks में क्या है? I mean, Lakshmikant, they have written it must be passed by both the houses of parliament. But you only understand if motion of thanks is defeated in Rajya Sabha, government may not have majority in Rajya Sabha. 4 instances have happened. There may be 4. 4 I can recollect. One during Indira Gandhi ji's tenure, second during Atal Bihari Vajpayee ji's tenure, and 2 times during the Honorable Present Prime Minister ji's tenure. 4 बार ऐसा हुआ है जो Rajya Sabha has passed the motion of thanks with some amendment. Okay. So usually the Rajya Sabha will pass in the original form, but they can pass with some amendment. Of course, the defeat of motion of thanks in Lok Sabha will lead to the defeat of the government. So motion of thanks क्या होता है? After the president leaves the house, then the discussion जो 2-3 दिन तक चलता है, in that discussion the opposition and the government will speak and they will thank thank the Honorable President for coming there. This is under Article 86 and 87 of the Constitution. This is something which is important. All the members are given oath. This year they can ask a question. They can also ask on pro tem speaker. अब UPSC क्या question पूछेगी? The Constitution of India explicitly provides for pro tem speaker. इस सब term Constitution में mention नहीं है. Constitution कहता है कि whenever the office of speaker is vacant and there is no deputy speaker, then the president will appoint someone as acting speaker, who is called as pro temporary speaker. In short form, we say pro tem speaker, as it is. So explicitly, the Constitution does not mention the term pro tem speaker. Lakshmikant mentions the same. Okay. So the point is, of course. अब प्रोटेम स्पीकर यू नो आई थिंक एंड ही एडमिनिस्टर्स द ओथ. एक मैं आपको चार्ट बता देता हूं. दिस चार्ट यू फॉलो एंड ऑलवेज दिस विल हैपन. ओके, नाउ दिस चार्ट से मतलब आई विल नॉट से दे विल आस्क अ क्वेश्चन, बट मेनी टाइम्स दे हैव आस्क्ड दिस क्वेश्चन फ्रॉम दिस चार्ट. सबसे पहले आई विल टेक हाइपोथेटिकल डेट्स, एक दो दिन का आगे पीछे हो सकता है. सबसे पहले ऑन 23rd May फॉर एग्जाम्पल, 23rd लास्ट 2019, 23rd 24 में डेट इलेक्शन रिजल्ट्स आए. इलेक्शन रिजल्ट्स आते हैं, ठीक है. सबसे पहले इलेक्शन रिजल्ट्स विल कम. उसके दूसरे दिन आप फोटो देखिएगा एक न्यूज़पेपर में. मैंने आई हैव सेड बिफोर आल्सो, मई में तो अभी इलेक्शन हुआ, मैंने पहले बोला था कि जस्ट सी दिस विल हैपन. चीफ इलेक्शन कमिश्नर प्लस 2 इलेक्शन कमिश्नर्स विल मीट द प्रेसिडेंट and they will officially hand over the list of winners to the president. President should not get to know the list of winners from news channel. So officially the list of winners will be communicated to the president by the chief election commissioner. ये इंडिया में कन्वेंशन है. सबसे पहले इलेक्शन रिजल्ट आएगा. इलेक्शन रिजल्ट के दूसरे दिन चीफ इलेक्शन कमिश्नर और इलेक्शन कमिश्नर मिलेंगे प्रेसिडेंट से और लिस्ट ऑफ विनर. उसके बाद आफ्टर दैट the whichever party has got majority, they will have the meeting of that party in the central hall of the parliament and they will choose their leader, which is a formality. Why? Because if the party had the face of Modi ji or Rahul Gandhi ji, then it is quite settled proposition that he only will be elected as the leader of the party. This time that meeting happened late, for the meeting of coalition leaders happened. Anyways, the whoever is the prime minister designate, he will prime minister designate, he will collect the letter of support, or if he is having majority, then he will have the endorsement by his political party. Then he will seek an appointment with the president. वो president से मिलेंगे and he will tender resignation. Even if the same person is to be appointed as prime minister again, everything will happen afresh. Everything, ये नहीं वहीं पे लिख दीजिए, नहीं ऐसा नहीं है कि ठीक है. So everything will happen afresh. So the prime minister will resign and the president will request the prime minister to continue as the one thing always remember. Office of prime minister cannot remain empty for a single day. I know many of you know, but those who don't know, office of prime minister cannot remain empty for a single day. On 27th May 1964, Nehru ji died. Immediately Gulzari Lal Nanda ji was appointed as prime minister. After few days, Lal Bahadur Shastri ji became prime minister. On 10th and 11th January midnight, unfortunately Shastri ji died. Again Gulzari Lal Nanda ji was appointed as prime minister. After few days Mrs. Gandhi became. On 31st October 1984 Mrs. Gandhi got assassinated unfortunately. Evening mein Rajiv Gandhi ji was administered oath of office. In August 1979 Chaudhry Charan Singh ji, great farm leader, he was the prime minister who couldn't face Lok Sabha. He was not having support. Still he continued as the prime minister. Mid 1979 में सरकार गिर गई. Still he continued as the prime minister till January 14th 1980 when Mrs. Gandhi was back as the prime minister. A petition was filed in Supreme Court. Supreme Court said under no circumstances on earth office of prime minister cannot remain empty. If I am the prime minister and I have lost majority, or then also I will continue to be the prime minister till the time next prime minister is appointed. या तो election होगा 4 months back, there will be time will be taken. Till that time I will continue as the prime minister. And then so in August or July August 1979 Chaudhry Charan Singh ji lost majority. Still Sanjeeva Reddy ji asked him to continue as the prime minister and directed the election commission to conduct election which were conducted in January 1980. 3rd से 6 January उस time जल्दी election हुआ. 14th January 1980 Mrs. Gandhi took oath as prime minister. So for 5 months Chaudhry Charan Singh ji was not having majority, still continued as the prime minister. On 27th May 1996, Vajpayee ji resigned as prime minister, that famous speech which he gave, but he was asked to continue as the prime minister on 1st June 1996. Then you have H.D. Deve Gowda ji became the prime minister. So office of prime minister cannot remain एम्प्टी। अगर मेजोरिटी लूज भी कर दिए हैं, जब तक दूसरा प्राइम मिनिस्टर नहीं आएगा आपको कंटिन्यू करेगा। इट इज नॉट लाइक स्टेट वेयर यू कैन इंपोज प्रेसिडेंट रूल। इसके पीछे रीजन ये है आर्टिकल 74, द प्रेसिडेंट विल ऑलवेज एक्ट ऑन द एड एंड एडवाइस ऑफ काउंसिल ऑफ मिनिस्टर्स अनलेस द इम्प्लिसिट डिस्क्रिशन इज देयर। 1996 लोकसभा इलेक्शन, नो पार्टी वाज हैविंग मेजोरिटी, सो बीजेपी वाज इनवाइटेड एज सिंगल लार्जेस्ट पार्टी, इम्प्लिसिट, अदरवाइज प्रेसिडेंट विल एक्ट ऑन द एड एंड एडवाइस ऑफ काउंसिल ऑफ मिनिस्टर्स एट मैक्सिमम कैन आस्क टू रिकंसिडर वंस। अब गौर से सुनिए, इलेक्शन रिजल्ट आएगा, लिस्ट हैंडओवर होगा, देन द प्राइम मिनिस्टर विल मीट द प्रेसिडेंट एंड दे विल चॉक आउट द डेट ऑफ ओथ। ओथ सेरेमनी होगी। आफ्टर ओथ सेरेमनी द न्यू कैबिनेट will recommend the president on the first session of 18th Lok Sabha. First session of 18th Lok Sabha मान लिया जाए 17th ही मान लें। 17th Lok Sabha was on 17th June 2019 Monday. Just on 17th June, just before 17th June, the अभी जो all the 543 members who have got elected, one among them will be appointed by the president as pro tem speaker. गौर से सुनिए, whenever the first session of a new Lok Sabha is about to begin, the outgoing speaker continues to be in office till the first session of new Lok Sabha. जिस दिन first session होगा नई लोक सभा का, just a day before, of the new people who have won the election, whoever is one of the most experienced person, can be from ruling party or opposition, president will call him to Rashtrapati Bhavan and will administer him oath of office as a pro tem speaker. तब on 17 June new Lok Sabha started. For 3 days everybody will take oath. Then pro tem speaker will preside over the Lok Sabha. उनका काम है सबको oath दिलाना. His job is to administer oath. सब जब oath ले लेंगे, then he will say, as per the rule 7 of Lok Sabha, I have been communicated by the president that the election of speaker will take place on 24th of June. Anybody who wants to file nomination can file in the Lok Sabha secretariat. He will say, then the election, on the date of election of speaker, usually election नहीं होता है, unopposed होता है, only once that taken place. He will say, I have received only one nomination paper of Shri Om Ji Birla, honorable member of parliament from Kota. I hereby declare him as the speaker. जैसे ही he will say this, prime minister will rise as the leader of opposition. They both will go to the person and they will bring him to the chair. The pro tem speaker will congratulate and go and sit like a member, and everybody will then start praising that, all those things. Okay, so the point is, who administered oath to the, now the question UPSC will ask, who administers oath to the speaker? Okay, so there is no oath of the speaker. He only took oath as a member of parliament. ये question UPSC पूछ सकती है, who administered oath to the speaker? When he was taking oath, he took oath as a member of parliament. There is no oath. Okay, now just we will take just few topics we will do, then we will in this. Now this is oath of members of parliament, all such thing, that forms of oath are given in 3rd schedule. 3 oaths are not given in the constitution: president, vice president and governor. This is given in article, not in the 3rd schedule. Pure UPSC prelims question, which of the following oaths are found in 3rd schedule, and in between they will insert oath of vice president, oath of president, and then they will say 1 correct, 2 correct, 3 correct, 4 correct. Most likely you will make a mistake. Some oaths are provided in the articles of the constitution, while all the oaths are provided in 3rd schedule of the constitution. Oath of president, vice president and the governor is provided in the constitution. Okay, so now we have this, what we have reached till now, this we were supposed to do yesterday. Okay, so now we will see 5 minutes we'll take, 1 hour, then we'll take a break. Now Citizenship Act. Now listen, 5 ways you can acquire citizenship: birth, registration, incorporation, naturalization and descent. What is section 6A that was in news? गौर से सुनिए, section 6A कुछ भी नहीं है. As per the Assam Accord, एक चीज डिसाइड की गई थी. All those who entered Assam from 1951 to 1966 will be given citizenship. Those who entered from 1966 to 1971, they will initially not be given citizenship, but they will be deemed to be citizens except for voting. क्यों? Because election was about to be held, so they should not impact the voting pattern and all. 1970, so 3 भाग में divide किया गया था. Those who came after 25th March 1971, they are illegal migrant. Those who came till 1966, they are citizens. Those who came from 1966 to 71, they will not be having all the rights of citizen for 10 years, and after 10 years they will. So a petition was filed in Supreme Court that this is violation of Article 14 of the कॉन्स्टिट्यूशन। क्यों वायलेशन है आर्टिकल 14 का कॉन्स्टिट्यूशन का? क्योंकि वाइड इज डिस्टिंक्शन, 66 तक यू आर citizen, 66 to 71 you are citizen, after 10 years after 71 you are not citizen. So this is an arbitrary classification between those who entered after 71, those who entered between 66 to 71 and those who entered before 66. The petitioner claimed that everybody who came after 1951 should be declared as an illegal migrant. इस पेटिशन को सुप्रीम कोर्ट ने रिजेक्ट किया और सेक्शन 6A was declared as कॉन्स्टिट्यूशनल। 3 भाग में डिवाइड किया गया था। जो 1951 से 66 तक आए दे आर लीगल, 66 से 71 तक आए दे आर ऑल्सो सिटीजन, पर उनको 10 साल तक वोट नहीं, ताकि बिकॉज पॉलिटिकल पार्टीज एट दैट टाइम वर एप्रीहेंसिव कि अभी जो इलेक्शन आ रहा है ये लोग वोट देकर हरा देंगे। सो गेटिंग माय पॉइंट, सो दे सेड कि नो, सो गेटिंग माय 71 में दे विल व्हाट यू कॉल गेट। नाउ दिस टॉपिक इज देयर, बट आई एम दोज हु हैव अटेंडेड द क्लास good, but I am almost confident that you don't understand NRIC, NPR and CAA. I know because you just see on WhatsApp. So briefly 2 minutes NRC, and they have not asked NRIC, NPR and CAA. I could have shown the articles also, but we don't have time. But I am almost confident that if you have not attended the class, I have hardly found a single student who has clarity of NRIC, CA if you have not attended the class. This I am not saying, honestly saying. Okay, everyone knows CA, without knowing the content. NRIC जो है एक statutory mandate है. It is a statutory mandate. It is a statutory mandate. ये है mention section 14A में, National Register for Indian Citizens. Section 14A किसका भाई? Citizenship Act 1955. 22nd December 2003 को एल.के. आडवाणी जी इंट्रोड्यूस द बिल। 7th January 2004 को एपीजे अब्दुल कलाम साहब अप्रूव द बिल। 3rd December 2004 को सेक्शन 14A केम इनटू फोर्स। 3rd December 2004। 3rd December 2004. Okay. No NRC. NRC is a statutory provision. It is provided in Citizenship Act. It is the compulsory registration of all citizens in India. No NRC has ever been undertaken in India, except one register was prepared in 1951, but that was not under section 14A. One. Second, second important thing, कि section 6A provide for NRC, but that is only for the state of Assam. Other than that, no NRC has ever been conducted in India, because section 14A add ही किया गया है 2004 में, came into force on 3rd December 2004. Assam के लिए अलग से provision है 6A, which has been conducted already. Otherwise NRC जो है वो section 14A है. NPR is not mentioned in Citizenship Act. ये mentioned है Citizenship Rules 2003 में. NPR is the normal register for all the citizens. What is the difference between NPR and census? Census is under Census Act of 1948. NPR में hardly I have shown in the class of the 10-12 details are taken. But census में बहुत सारे details taken होते हैं. आप गाड़ी own करते हैं, मोटर बाइक own करते हैं, qualification क्या है, family में कितने कमरे, multiple details are stated NPR. And Citizenship Act, NPR was first conducted in 2010. It was merged with Aadhaar data into 2015, updated बोलते हैं इसको. NPR की सबसे बड़ी खूबसूरती है, I can show you the website also, Census India में मिल जाएगा, साफ लिखा हुआ है, it is a self declaratory exercise. Even आप जाके डिक्लेयर कर दीजिए कि आप अंटार्कटिक के, आप मार्स के सिटीजन हैं, वो लिख देगा, वो आपसे कुछ नहीं. So it is a self declaratory, it is no documents are needed for NPR. NPR में लिखा हुआ है no document required, self declaratory exercise, whatever you say they will write, they will not ask for a document. Tomorrow if now NPR में for example 97 people said they are Indians and 3 people said that they are foreigners. Tomorrow when NRC register will be prepared, these 97 people as per a constitutional scholar who have declared themselves in NPR, they will be asked to produce document. So NRIC has not been conducted. ये conduct हुआ है 2010 में, update हुआ. अब 2025 में जो census होगा उसमें again NPR will be conducted. CAA क्या है? This is CAA में amendment हुआ, section 2 of the Citizenship Act. You can easily download. कहता है whoever belongs to Hindu, Sikh, Buddhist, Jain, Parsi and Christian. So कौन दी दो community नहीं है? Jews and Muslims. Okay, Jews and Muslims. Hindu, Sikh, Buddhist, Jain, Parsi or Christian who entered India before 31st December 2014, जो 31 दिसंबर 2014 तक इंडिया इंटर कर गए, who have been exempted by the government under Passports Act and Foreigners Act, Passport Entry into India and Foreigners Act, they will not be treated as illegal migrants. So what is CAA? CAA Section 2 provides exemption to those people who are Hindu, Sikh, Buddhist, Jain, Parsi and Christian, coming from only 3 countries, Bangladesh, Afghanistan and Pakistan, not Sri Lanka, not Iran, not any other country. इन 3 कंट्री से ये 6 समुदाय के लोग नॉट आफ्टर 31st December till 31st December 2014, if they entered into India, they will not be treated as illegal migrant and they will be given citizenship through registration or naturalization. एक और बात है, the period of stay, this act came in 2019 and the cutoff date is 2014, so minimum year of stay has been kept as 5 years. थर्ड शेड्यूल को अमेंड कर दिया गया, वहां इन प्लेस ऑफ 11 दे विल रीड 5 years. सो यही है CAA. सो फर्स्ट, CAA is not applicable to any person other than those who come under this category. So an average Hindu, Sikh, Buddhist, Parsi, Jain, Christian will not come under CAA unless he has come from Pakistan, Afghanistan and Bangladesh and exempted by the central government under Passport Act and Foreigners Entry into India Act, then only you will be treated as a what you call, this is CA. This is 2019, 12th December 2019, this is there. NPR हो चुका है already, ये फिर होगा, अभी फिर census is going to happen, NPR will happen, NRC has not happened, it will happen, it has only happened for Assam. Prime Minister on record has said 2 times that the government is not conducting any such NRC now. So this is a statutory mandate, this is a, NPR is an example of delegated legislation. Because it is just a rule, it is not mentioned in the law. But CAA is a classic example of a ordinary legislation. Let's see. Now, dear students, yahi hai, it 5 ways to get citizenship. Section 6 is a special provision after Assam Accord. It confers citizenship to those who migrated to Assam from 1st January 1966 to 24th March 1971 on the completion of 10 years. इसको सुप्रीम कोर्ट ने कहा कि नहीं, 6A को, कुछ लोगों ने कहा था कि 6A डिस्क्रिमिनेटरी है, यू आर क्रिएटिंग अननेसेसरी कट ऑफ डेट, दिस इज नॉट रीजनेबल क्लासिफिकेशन. सुप्रीम कोर्ट ने कहा नहीं, बिल्कुल रीजनेबल, इट इज बेस्ड ऑन असम अकॉर्ड. ओके, सो दिस इज फॉरनर्स ट्रिब्यूनल बनते हैं, कॉसी जुडिशियल बॉडीज हैं, दे आर ओनली फॉरनर ट्रिब्यूनल्स हैव द पावर टू डिक्लेयर अ फॉरनर, डज नॉट ऑटोमेटिक गिव द, दे हैव अ पावर ऑफ सिविल कोर्ट. सिटीजनशिप रूल्स वर अमेंडेड. ओके, सो दीज आर द क्राइटेरिया इन विच वन कैन गेट ओवरसीज सिटीजन ऑफ इंडिया. यू नो, 2015 January, person of Indian origin was merged with overseas citizen of India card holder scheme. क्या क्या फायदे हैं? You can work in India. Okay. You can buy any property except agriculture and plantation properties. You can stay in India without visa. You are not required to visit a FRRO office. A foreigner has to register in foreigners regional registration office. You are not required. You can work as a doctor, chartered accountant. You can sit in IIT JEE, All India Pre-Medical Test, which now is NEET. Okay, सारे exam दे सकते हैं, professional है. सारे facility to overseas citizen of India cardholder scheme. This is, and then after certain years of stay, you will be eligible for citizenship, of course. So overseas citizen to reignite the connection with diaspora. इसमें क्या क्या है? What are the ways? So you get present an affidavit of correctness of the statement, renouncing the citizenship of the country. Authority 6B application shall be submitted. So abhi 4 conditions hai. Illegal migrants who fulfill the 4 conditions will not be treated as illegal migrant. These are Hindu, Sikh, Buddhist, Jain, Parsi and हाँ एक चीज और, Citizenship Amendment Act 2019 is not, 2 एरिया में ये अप्लाई नहीं होगा, इनर लाइन परमिट वाले एरिया में और 6 शेड्यूल में. So in Assam, Meghalaya, Tripura and Mizoram, 10 districts which have been declared as autonomous district, वहाँ ये जाके settle नहीं कर सकते हैं, and they cannot settle in those inner line permit areas. So Citizenship Amendment Act benefit will not be extended to CAA areas. Why? Because then the demography, tribal for example, Hindu, Sikh, Buddhist, Jain, Parsi, Christian coming from Bangladesh, if he will settle in the 6 schedule areas and if he will settle in the inner line permit areas, then the tribal demography may change. So CA is exempted from ILP areas and Assam, Meghalaya, Tripura and Mizoram. This is 5 grounds of cancelling the OCI card, all such things. This we will complete all the things related to OCI, what you call foreign military personnel are not entitled for OCI if you are in foreign army, persons of Indian origin, all such thing. So ये सारे criterias हैं, multiple entry, lifelong visa, eligibility for Indian citizen, they do not have the right to vote, they cannot take any constitutional office, okay, all such things are not there, not eligible to take constitutional office, all such things, पर हाँ, they can work in India except research. They can work in India except for research, they need special permission. They can buy property except agriculture and plantation properties. They can, lifelong visa hai, they can do any, all such things are there. They will be later on also, of course, eligible if they stay for long. All such things are there. That is Overseas Citizen of India Cardholder Scheme. Now, reservation and affirmative action में 29 सितंबर 2023 को एक बहुत ही लैंडमार्क जजमेंट आया है, फेयर एडमिशंस वर्सेस हार्वर्ड, जो मैंने करंट अफेयर्स में भी जजमेंट तो नहीं बस दे, दैट वी विल सी बिकॉज दिस इज लाइकली टू बी आस्क्ड, मेंस में ऑलरेडी क्वेश्चन आ गया है, क्योंकि लास्ट ईयर 2023 में देयर वाज अ जजमेंट फेयर एडमिशंस वर्सेस हार्वर्ड यूनिवर्सिटी, जिसमें अमेरिकन सुप्रीम कोर्ट ने a previous judgment ko racial reservation in Harvard University was declared as unconstitutional and violation of 14th Amendment of the American Constitution and Civil Rights Act of 1964. So reservation was declared as unconstitutional in the landmark case Fair Admissions versus Harvard last year. Now what is the, इसीलिए यूपीएससी ने दो क्वेश्चन पूछा, व्हाट इज द प्रोविजन ऑफ इक्वालिटी इन अमेरिकन कॉन्स्टिट्यूशन विज विज इंडियन, मेंस में पूछा, प्रीलिम्स में दे कैन आस्क बेसिकली अबाउट द प्रोविजन ऑफ अफर्मेटिव एक्शन इन इंडियन कॉन्स्टिट्यूशन. सो वी कैन टेक अ ब्रेक, वी कम बैक, देन वील डिस्कस दिस. आई डोंट नो व्हाट टाइम वी हैव. So please settle down. Now see what all questions can be asked. That with respect to America में affirmative action, what is the difference between America and India? What is the difference between America and India? गौर से सुनिए. In Indian Constitution, it is explicitly mentioned, Article 15, Clause 4, nothing shall prevent the state from providing any special provision for the advancement of socially and educationally backward classes and SC, ST. Article 15, Clause 5, reservation in educational institutions. Article 16, Clause 4, reservation. I am presuming that those students who are coming for PT 365, I am presuming that you have read Article 15 and Article 16 of the Constitution. One thing I would say that I just something remember कि conceptual question 5, 6 ही पूछ रहे हैं repeatedly. Either they are asking a conceptual question on Article 14, or they are asking a conceptual question on Article 21, or they are asking on Article 25, or they are asking judicial review, or they are asking separation of powers. So many students come to me that whether we should read DD Basu or not. When we know that they are asking conceptual questions on these topics only, so these topics you can read a standard book other than the Lakshmikant. On Article 14 के concept में preamble, हाँ preamble 14, 21, 25, separation of powers, federalism, ये दो चार चीजें hardly it will take 4 hours. You read from standard book. इससे उसमें भी if you want to curtail, just read Article 14, Article 21 and preamble and separation of powers from DD Basu, ताकि आपको लक्ष्मीकांत से थोड़ा जैसे ड्यू प्रोसेस ऑफ लॉ वाला क्वेश्चन था लास्ट ईयर, ओके फेयर जस्ट एंड रीजनेबल, सो वो यू कैन इजिली डू इफ यू विल गो बाय लक्ष्मीकांत, वहां लिखा हुआ है फेयर जस्ट एंड रीजनेबल, आप सी टिक करके आगे बढ़ जाएंगे यू विल, बट द आंसर वाज प्रिंसिपल ऑफ नेचुरल जस्टिस. सो ये सब गलत नहीं होगा इफ यू विल रीड फ्रॉम DD Basu also other than what is given. Now listen here. So what is the difference between America and India? In America, it is India, it is explicitly provided. In America, it is not explicit provided, but an interpretation. To do historical discrimination, untouchables and women, here it is minority groups. Socially and educationally backward classes, economically weaker section, yeah, Hispanic, based on quota system, diversity, equity and all. Upper ceiling, no upper legal limit. अब ये चलिए, ये तो ठीक है. First, in American, what is the difference between fundamental rights and equality in American Constitution with that of Indian Constitution? क्या है, क्या difference है? पहला, Indian Constitution fundamental rights are from day one. In American Constitution, fundamental rights were added by constitutional amendment. दूसरा, in Indian Constitution, fundamental rights are qualified. In America, they are relatively absolute. तीसरा, in Indian Constitution, fundamental rights explicitly provide for reservation. Article 15 clause 5, Article 15 clause 6, Article 16 clause 4, Article 16 clause 6. In America, there is no explicit mention of reservation. पांचवा, in India, there are explicit provisions for untouchability. Article 17, ये बहुत important, religious and linguistic minorities. Article 30. There is no explicit mention for religious and minority rights in American Constitution. आगे, in Indian Constitution, we have procedure established by law. American, you have तो चलिए फिफ्थ अमेंडमेंट अमेरिकन कॉन्स्टिट्यूशन का, फिफ्थ अमेंडमेंट ड्यू प्रोसेस ऑफ लॉ. आगे, in Indian Constitution, rights are more elaborate. For example, immoral trafficking, bonded labor, begar, human trafficking. In America, it is not there. Child rights also India may explicitly mentioned. Next important thing, in Indian Constitution, the सबसे important तो explicit mention of reservation है. ये सारी difference between हमें affirmative action है, substantial कुछ चीज़ें, ये basically means का point है. Prelims में they will not ask, but principle of equality से मैं फिर से कह रहा हूँ, अगर वो you just go and see, अगर concept से if they are asking a question from concept, वही घिसा पिटा वही 5-7 concept they are asking, equality, equity, due process of law, procedure established by law, fraternity. So from DD Basu or in standard book, जो अच्छी book है, you will read preamble, you will read Article 14, Article 21, उतना, और separation of powers, ये सब पढ़ लेंगे, judicial review, then you will have your idea, because concept said I have the entire constitution over here. If I see these are the areas where they will ask you. They cannot ask a question on concept from Article 323 administrative tribunals और elections. वहाँ वो concept question पूछेंगे, या तो fundamental rights से पूछेंगे, या तो preamble से पूछेंगे, या तो federalism और separation of powers से पूछेंगे. So you read these topics from, so एक जो conceptual question आता है which they frame by themselves, you will be able to correctly answer that question. ये American है. This is one of the favorite judgment, sub classification. गौर से सुनिए. I see we have running short of time, so I'll give you the what you call hint. सबसे पहले in India, सबसे पहले you have सबसे पहले states have a different parameter. I'm not going into states. There are 28 states in India. तो हम states पे नहीं जाएंगे. Bihar has EBC, BC1, BC2, all such things. Okay. Central level पे Article 341 declares who is a scheduled caste. Article 342 declares who is a scheduled tribe. And Article 342A declares who is a OBC, that is backward classes. Pehla. Second, Article 341 and 342 is part of original constitution. 342A OBC, there was no concept of OBC, it was added by 102nd Constitutional Amendment Act 2018 में, otherwise it was through a statutory provision. Second point. Third, अभी बहुत important fact आ रहा है और इससे question आएगा क्योंकि judgment आया है. Judgment I have read, I can talk for next 2 hours, पर उसमें 2 तो नहीं, कम से कम half an hour, but I will not go waste time in that. अब गौर से सुनिए. Article 341 and 342 में एक ही SC list है. The states cannot have their own SC list. State cannot have their own ST list. There is only one SC list and there is only one ST list. System क्या है? On internet you will type Presidential Order Schedule Caste 1950. SC list खुल जाएगी. Presidential Order Schedule Tribe ST list खुल जाएगी. Article 341 of the Constitution says President will declare who is an SC. So first time President declared in 1950. 1950 में पहली बार प्रेसिडेंट ने डिक्लेयर कर दिया दीज ऑल कम्युनिटीज स्टेट वाइज आर शेड्यूल कास्ट एंड शेड्यूल ट्राइब. उसके बाद मेनी टाइम्स अमेंडमेंट वर मेड. कॉन्स्टिट्यूशन कहता है प्रेसिडेंट विल डिक्लेयर एससी, पहले एससी डिक्लेयर हो गया, उसके बाद टाइम टू टाइम अमेंडमेंट विल बी मेड बाय द पार्लियामेंट. अमेंडमेंट कौन करेगा? पार्लियामेंट. सो नो स्टेट कैन डिक्लेयर देयर ओन कम्युनिटी एज एससी. स्टेट, ये इस पे बहुत सारी लड़ाइयां, आई विल नॉट गो इनटू दैट, बट यू फाइनली यू अंडरस्टैंड स्टेट्स कोई किसी को ना एससी बना सकते हैं ना हटा सकते हैं. नीदर एससी कैन बी मेड बाय स्टेट नॉर एक्सक्लूड. व्हाट इज द प्रोसेस? प्रोसेस ये है, द स्टेट गवर्नमेंट विल मेक अ रिक्वेस्ट टू सेंटर. Center will send the request to 2 bodies, Registrar General of India and National Commission for Scheduled Caste, Scheduled Tribe or Backward Classes. Once receiving the recommendation of Registrar General of India and National Commission for Scheduled Caste, Scheduled Tribe or Backward Classes, which is not binding in nature, then Cabinet will approve an amendment. In the next session of Parliament, you will see Presidential Order Scheduled Caste Amendment, Presidential Order Scheduled Tribe Amendment by simple majority. Last 5 years, there have been many events when SC and ST list has been amended by the Parliament. Conclusion, brief mein, SC list was first declared by the President in 1950. From 1950 to 2025, it has been amended zillion times. Every times only one person is authorized to amend, that is the Parliament of India, one authority, Parliament. हाँ, Constitution explicitly states that governor will be consulted, but the state को consult किया जाएगा, but that is not binding upon the center. So SC list में there is only, states cannot have their own SC list, state cannot have their own ST list. There will be one, हाँ, state request कर सकते हैं. अब आया OBC. There was no concept of OBC. August 1990 OBC came as 16th November 1992 as Indira Swani versus Union of India. Judgment आया, OBC का concept आया. From 1992 till 2018, SC one SC list, ST one ST list. OBC में कोई छेड़छाड़ नहीं किया. From 1992 OBC came, there was a central OBC list and there was a state OBC list. SC only one list, ST only one list. If the state wants to add something, it will request the center. Center will consult the Registrar General, Commission and Parliament by simple majority will amend. In last 5 years, 2-3 instances I have seen SC list and ST list has been amended by the Parliament. State request करेगा. OBC में सेंटर कोई छेड़छाड़ नहीं. Center did not touch, tinker with the. There will be one OBC list for the state and there will be one OBC list for the center. 1992 से 2018 this was going on. In 2018 by 102nd Constitutional Amendment Act, they added Article 342A और कहा there will be a presidential order on backward classes like it is for scheduled caste and scheduled tribe. अब हो गया कि there will be a national OBC list. Maharashtra government declared a community as OBC. Matter went to Supreme Court. Supreme Court said बिल्कुल नहीं. Now from 2018 there will be no state OBC list. There will be only one OBC list because Article 341, 342 and 342A language is exactly same. How can you expect us to interpret 3 articles differently when the language is same? So अब state की अपनी कोई OBC list नहीं होगी. पूरा अप्रोर हो गया, ह्यूज, बिकॉज ओबीसी इज अ वेरी हेट्रोजेनस कम्युनिटी, इट इज इम्पॉसिबल टू क्लासिफाई एट, इम्पॉसिबल तो नहीं है, बट इट रिक्वायर्स एफर्ट टू क्लासिफाई एट नेशनल लेवल ओनली. स्टेट्स, फॉर स्टेट जॉब्स बेसिकली नॉट इम्पॉसिबल, गवर्नमेंट डजंट वांट टू इंटरफियर विद द स्टेट. फिर क्या हुआ, आर्टिकल 137 में सेंटर ने रिव्यू पिटीशन डाला कि नहीं, आवर पर्पस इज एंटायरली डिफरेंट. 341 एंड 342 वी वांट ओनली one list. 342 we don't want. States can have their OBC list for State Public Service Commission, and UPSC we will come with our own central OBC. Supreme Court said. You read article 341, 342 and 342A. Exact language is same. So there will be only one OBC list. Within 1 month, Parliament amended by 105th Constitutional Amendment Act, article 342A, which was added in 2018. 3 years later it was again amended or add kar diya. There will be one central OBC list and states are allowed to have their own OBC list. So आज के डेट में there is one SC list, there is one ST list, and there are 2 OBC lists, central OBC list and state OBC list. State OBC list will be valid for State Public Service Commission, and central OBC list will be valid for center. Both will be made by DM, but you have to apply whether you are applying for central OBC or state OBC. And one more thing, if your community is in center OBC, for sure it is in state OBC. But if your community is in state OBC, not necessary it is in central OBC. Reason being, because central OBC list is compiled on the recommendation from the state. How can state recommend somebody to be included in central OBC list when they have not included themselves? So if you are in state OBC, not necessary you are in central OBC, but if you are in central OBC, necessarily you are in state. So ये पोजीशन है इंडिया में. सेंट्रल ओबीसी लिस्ट एक है, स्टेट ओबीसी लिस्ट है, एससी लिस्ट अलग है, एसटी लिस्ट अलग है, स्टेट्स की अपनी एससी लिस्ट नहीं है. अब आती है मेन लड़ाई. आंध्र प्रदेश एंड सम स्टेट्स वांटेड कि सेंट्रल ओबीसी लिस्ट में स्टेट वाइज दिया हुआ. आंध्र प्रदेश 10 कम्युनिटीज, बिहार 10 कम्युनिटीज. उन्होंने कहा वी वांट टू सब क्लासिफाई. व्हाट इज सब क्लासिफिकेशन? वेरी इजी. I am not allowed to take the name of the caste, of course not. Of course we are human beings, we have nothing to do with caste, but if I would have taken the name, you would have understood in nanosecond. But you know, we are limited. So the point is, अब गौर से सुनिए. For example, Bihar, United States of Bihar. Okay. In United States of Bihar, from 1 to 10 communities who are in schedule caste, schedule caste. Now in this there are 2 communities, दो community A और B है, which is in sociology you study dominant caste, जो within SC जिनकी संख्या, I have so many friends from scheduled caste, scheduled tribe, so many friends. So they mostly come from those scheduled caste communities who are more dominant in nature. So if 15% reservation is for scheduled caste, ये दो community पूरा 15% garner करिए, rest 8 communities are not getting 15%. So आंध्र प्रदेश ने कोशिश की कि एक काम कीजिए, give us, we will not change the SC list, but please allow us to classify that out of these 15% भी कोई श्योर नहीं है. Bihar is giving 1.5% to scheduled tribe because our brothers and sisters from scheduled tribe community went to Jharkhand 15 November 2000. What every state has a liberty, they can give 15%, 10%, whatever depends upon them. मान लिया 15% है, सेंटर के लिए नहीं, स्टेट गवर्नमेंट जॉब्स के लिए. सो आंध्र प्रदेश विल से, सुनिए ना, इन दोनों कम्युनिटीज को वी विल गिव 3% एंड रेस्ट 12% वी विल रिजर्व फॉर दिस एज का. ये जजमेंट आया 2004 में ईवी चिनैया जजमेंट, वेरी इंपॉर्टेंट. सुप्रीम कोर्ट ने कहा बिल्कुल नहीं, स्टेट्स हैव नो राइट टू टच द सेंट्रल एसटी लिस्ट एंड सेंट्रल एससी लिस्ट. अब यही जजमेंट आया 1 अगस्त को, स्टेट ऑफ पंजाब वर्सेस देवेंद्र सिंह, जो जजमेंट अभी आया. सुप्रीम कोर्ट ने कहा स्टेट कैन सब क्लासिफाई एससी लिस्ट, स्टेट चाहे तो सब क्लासिफाई कर सकते हैं. ऑन अ लाइटर नोट, आई एम केयरफुली नोटिंग, not every day, but I once noted what is the comment from political party. In state of Punjab versus Devendra Singh 2024 judgment, Supreme Court said 2 things. One thing it ruled, one thing it observed. आपको मालूम है Supreme Court judgment is divided into 2 parts. एक 500 pages है, तो 480 pages will be obiter dictum. और इसको कहेंगे रेशियो डिसिडेंडी. रेशियो डिसिडेंडी 20 पेज होगा. दिस इज द बाइंडिंग पार्ट ऑफ द जजमेंट. दिस इज जस्ट ऑब्जर्वेशन मेड बाय द कोर्ट. It is not binding. So judgment is divided into 2 parts. जब observe लिखा रहता है, opined लिखा रहता है, either it is article 143 or observation made by the court, जिसको हम कहते हैं obiter dictum. और ये जो होता है ratio decidendi, this is the binding part of the judgment. So one thing was in ratio decidendi, one thing was in obiter dictum. Obiter dictum में सुप्रीम कोर्ट ने कहा there should be creamy layer for SC ST, जिसमें ऑन रिकॉर्ड गवर्नमेंट ऑफ इंडिया मिनिस्टर, ऑनरेबल मिनिस्टर ने कहा गवर्नमेंट ऑफ इंडिया इज नॉट कॉन्टेम्पलेटिंग टू हैव एनी क्रीमी लेयर फॉर SC ST। तो वो मामला तो दैट थिंग गॉट सेटल्ड। इसमें द स्टेट्स वर अलाउड टू सब क्लासिफाई, स्टेट चाहे तो इसमें अपना सब क्लासिफाई कर सकते, दिस वाज अलाउड बाय द सुप्रीम कोर्ट कि अब चाहे। अब इसमें क्या है, गौर से सुनिए। फॉर एग्जाम्पल देर आर 2 पॉलिटिकल पार्टीज इन बिहार एंड 2 पॉलिटिकल पार्टीज इन यूपी और आंध्र प्रदेश और अरुणाचल प्रदेश, एनी स्टेट, ओके। सो दीज फॉर एग्जाम्पल पॉलिटिकल पार्टीज फ्रॉम दीज कम्युनिटीज, उनका प्रवक्ता है बोला दिस इज अ फर्दर प्लॉय टू डिवाइड अस, सेट की ये डिवाइड नहीं। सो वी मस्ट रिस्पेक्ट द पॉलिटिकल पार्टी, एवरीबडी हैज अ राइट टू हैव ओपिनियन। सो आई वांट टू नो व्हाट इज द पोजीशन ऑफ सेंट्रल गवर्नमेंट, बिकॉज सब क्लासिफिकेशन विल बी एट स्टेट लेवल, सेंटर इज नॉट कॉन्टेम्पलेटिंग, तो लड़ाई तो मेन स्टेट में, पॉलिटिकल इशू। सो दीज 2 पॉलिटिकल पार्टीज के जो रिप्रेजेंटेटिव्स है, विदाउट नेमिंग, वी हैव नथिंग अगेंस्ट, जस्ट सेइंग सो दैट यू अंडरस्टैंड, दे आर नॉट वेलकमिंग द judgment. They said ki the SC is a homogeneous community, but those political parties which have representatives from this, they are saying this is a very good judgment, this is a very good judgment, और ये तो पहले आना चाहिए था। And those political parties which are mainly nothing to do with SC, they are OBC, they are saying this is the most important judgment. Why? Because all of them voted for, now they want to, so some vote will come to them, so those, so it is, I am seeing every political party is commenting as per their own, central government is refraining, shying away from commenting। हाँ, क्रीमी लेयर पे सेंट्रल गवर्नमेंट ने बोल दिया कि नहीं, वी विल नॉट इंप्लीमेंट क्रीमी लेयर, सब क्लासिफिकेशन ऑफ शेड्यूल कास्ट। अब आप समझ गए SC ST 341 342 and 342A and what you call the sub classification। अब बिहार अपना EBC BC1, all these UPSC will not ask because it has to do with state। So this was a judgment delivered by Supreme Court, जो 2004 का जजमेंट उन्होंने ओवरटर्न किया देवेंद्र सिंह केस में कि नहीं भाई आप अपना सब क्लासिफाई कर सकते हैं। सो स्टेट ऑफ पंजाब वर्सेस देवेंद्र सिंह, सुप्रीम कोर्ट हेल्ड दैट सब क्लासिफिकेशन ऑफ शेड्यूल कास्ट इज permissible, you know article 341 342 and scope of sub classification। इससे पहले ईवी चनैया में सुप्रीम कोर्ट ने कहा था क्लास सब क्लासिफिकेशन ऑफ शेड्यूल कास्ट अमाउंटेड टू टिंकरिंग, मतलब छेड़छाड़, टिंकरिंग विद द प्रेसिडेंशियल लिस्ट, सो दिस एक्सक्लूसिवली वेस्ट विद द पार्लियामेंट। सो सुप्रीम कोर्ट ने पहले कहा था कि बिल्कुल नहीं, वॉट एवर इज द नेशनल SC लिस्ट आपको वही फॉलो करना है, यू कैन नॉट फर्दर सब क्लासिफाई। नाउ सुप्रीम कोर्ट हैज अलाउड कि ठीक है भैया, स्टेट्स कैन सब क्लासिफाई द शेड्यूल कास्ट एंड शेड्यूल ट्राइब विदाउट टचिंग द लिस्ट, दे कैन नॉट रिमूव और exclude, but within, for example 20 communities are SC in Bihar or 18, so Bihar government can say okay, we will give 16 of them 10% reservation and 2 of them only 2% रिजर्वेशन। ये सब क्लासिफिकेशन वो कर सकते हैं। ओबीसी इज अ वेरी हेट्रोजेनियस कम्युनिटी, दैट इज व्हाई स्टेट्स हैव देयर ओन ओबीसी लिस्ट, ओके। सो यूनिफॉर्म सिविल कोड इज अगेन दिस इज तो चलिए यूनिफॉर्म सिविल कोड 5, फर्स्ट यूनिफॉर्म सिविल कोड इज नॉट डिफाइंड इन द कॉन्स्टिट्यूशन, फर्स्ट थिंग। सेकेंड इंपॉर्टेंट थिंग, सबसे पहले इट इज नॉट डिफाइंड इन द मेंस का टॉपिक है, प्रीलिम्स में दे विल नॉट आस्क, बस कुछ चीजें प्रीलिम्स में याद रखना है। यूनिफॉर्म सिविल कोड कॉन्स्टिट्यूशन में डिफाइन नहीं है। सेकंड, इनहेरिटेंस, मैरिज, डिवोर्स, यू हैव मेंटेनेंस एंड व्हाट यू कॉल दिस थिंग अडॉप्शन, ओके। सो अडॉप्शन में और मेंटेनेंस में बाय लॉ यूनिफॉर्मिटी है। मैरिज में अंतर है कि हिंदू कैन नॉट मैरी समवन हुम यू आर रिलेटेड बाय ब्लड, अदर सेक्शन 5 ऑफ द विच आई ऑलवेज शो इन द क्लास, सेक्शन 5 ऑफ द हिंदू मैरिज एक्ट में एक्सेप्शन दिया हुआ है कि इफ योर कल्चर परमिट, सदर्न पार्ट ऑफ द कंट्री दे हैव द ब्यूटीफुल कल्चर, सो दे कैन मैरी समवन हुम दे आर रिलेटेड, अदरवाइज हिंदू कैन नॉट मैरिज। सो जो शादी है, मैरिज, डिवोर्स और व्हाट यू कॉल अडॉप्शन और इनहेरिटेंस और मेंटेनेंस, ये सब कम्युनिटीज का डिफर करता है। कैसे? पहला, मुस्लिम, अ मुस्लिम कैन मैरी अ कजन, but a Hindu can only marry a cousin under section 5 of Hindu Marriage Act if your custom allows the same in southern part of the country, otherwise a Hindu cannot marry a cousin, पहला। दूसरा, inheritance, inheritance तो मुस्लिम का very complex, that is why Muslim personal laws are taught in law colleges, because Muslim inheritance are guided by Muslim personal law, so they will be uniform inheritance laws. Then you have article 371A for Nagaland and 371G for Mizoram, parliamentary law will not apply on Nagaland related to their custom. Then you have divorce को लेकर for Muslim, triple talaq has not been, I told you yesterday, has not been declared as triple talaq is perfectly constitutional. Only instant triple talaq has been declared as unconstitutional. Muslim Women Protection of Rights on Marriage Act 2019 खोलिए, section 2 आएगा. Section 2 में लिखा हुआ है triple talaq means any talaq that is instantaneous and irrevocable. Talaqe ehsan and talaqe hasan, जैसे anybody said talaq and after 2 months you said another talaq. In between there is a compromise between husband and wife, it is still valid. The other forms of talaq are valid. Only any talaq that is said at 3 times at one go, that is unconstitutional and an offense. That ruled by Shaira Bano versus Union of India 2017 case, Muslim Women Protection of Rights on Marriage Act 2019. Instant triple talaq has been declared as unconstitutional. Other forms of talaq are constitutional. 1.5-2 years back, a petition was filed in Supreme Court कि instant triple, though talaqe ehsan and hasan should also be declared as unconstitutional. Supreme Court ने कहा for the time being, prima facie they look constitutional. सिर्फ instant triple talaq को Supreme Court ने कहा unconstitutional. So पहली बात, यूनिफॉर्म सिविल कोड इज नॉट डिफाइंड. सेकंड, ऑन दीज मैटर्स देयर इज यूनिफॉर्म सिविल कोड. थर्ड, इट इज नॉट अबाउट रिलीजियस डाइवर्सिटी, इट इज अबाउट रीजनल डाइवर्सिटी. सेक्शन इनफैक्ट नेशनल फैमिली हेल्थ सर्वे का अभी मैं 2 दिन पहले देख रहा था, मोर देन 20% मैरिजेस आर व्हाट यू कॉल कजन मैरिजेस आर लार्जली टेकिंग प्लेस इन द सदर्न पार्ट ऑफ द कंट्री. दे हैव देयर ब्यूटीफुल कल्चर. सो इट इज मोर अबाउट रीजन देन अबाउट रिलीजन. 371A नागालैंड, 371G मिजोरम जैसे 6 शेड्यूल में ऑटोनोमस डिस्ट्रिक्ट काउंसिल्स हैं, उनको सब पावर है. शादी ब्याह, यू हैव द व्हाट यू call inheritance, all such powers are with autonomous district council. They can make laws. So it is about linguistic diversity, language based communities, it is about religious diversity, it is about ethnic diversity, it is about caste based diversity. So इसी सब challenges हैं. I'm not going. हाँ, एक चीज याद रखना है, marriage, adoption, maintenance, all these things, ये inheritance, all these things are in entry 5 of the state, ये concurrent list. ये सारी चीजें किसके अंडर में है? concurrent list में. Entry 5 of the concurrent list is marriage. So इसमें law can be made by parliament as well as state legislature. If there is a clash, parliamentary law will prevail unless the state law gets the approval of the president. So एक चीज prelims में पूछेगा. Second, you see article 371A, article 371G, 6th schedule of the constitution, 5th section 5 of Hindu मैरिज एक्ट. आई डोंट हैव टाइम, आई ऑलवेज शो इन द क्लास, बट एनीवेज. सो ये सारी यूनिफॉर्म सिविल कोड है. यूनिफॉर्म सिविल कोड डिफाइन नहीं. अब पॉजिटिव क्या क्या है यूसीसी के बताने की जरूरत है. सेक्युलराइजेशन, जेंडर जस्टिस, यू हैव कॉम्प्लेक्स लॉज. जैसे लॉ कॉलेज में मैक्सिमम लड़के घुलटते हैं. आउट ऑफ 30 पेपर्स इन लॉ, मैक्सिमम फेलियर रेट इज फैमिली लॉ 2. फैमिली लॉ 2 में सब फेल करता है. क्यों? फैमिली लॉ 2 में हिंदू लॉ एज वेल एज मुस्लिम लॉ. और मुस्लिम लॉ में इनहेरिटेंस इज वन ऑफ द मोस्ट कॉम्प्लेक्स टॉपिक. दैट व्हाट यू कॉल हस्बैंड वाइफ, दे हैव 1 daughter 1 children, daughter has 1 property and ये brother has 2. उसको बताइए how what grandson will get. So you will not be able to solve, and it is pure maths, it is not law, it is pure maths. Unless you know the mathematical formula, you will not be able to calculate. So उसमें maximum students fail. So the complexity of laws will be done away with. There will be uniform law. So एक और फायदा होगा, there will be uniformity in legal structure. There will be secularization, gender justice होगा. It will lead to proper implementation of DPSP. ये सारा कुछ cases हैं जैसे सरला मुदगल केस. A person who is belonging to religion X, which doesn't allow polygamy, he converted overnight. Said, now I am belonging to a religion, my religion now allows. He married someone. So you are using personal laws for personal. So इसमें सरला मुदगल केस में सुप्रीम कोर्ट ने कहा. Then there is one case, जॉन वैलम एटम केस. सुप्रीम कोर्ट ने कहा कि सुनिए, जॉन वैलम एटम केस, सरला मुदगल केस, मोहम्मद अली खान वर्सेस शाह बानो केस, शायरा बानो केस एंड डैनियल लतीफी केस. दीज आर द 5 इंपॉर्टेंट केसेस ऑन व्हाट यू कॉल दिस यूनिफॉर्म सिविल कोड. अब इसमें एक जोज पॉल कॉन्टिनो केस, गोवा, यूनिफॉर्म सिविल कोड ऑफ गोवा इज द शाइनिंग एग्जांपल, दिस सुप्रीम कोर्ट सेड. अब इन वन केस व्हाट हैपेंड, सुप्रीम कोर्ट सेड, टेल मी हाउ इनहेरिटेंस इज अ रिलीजियस मैटर. How will I distribute property to my daughter and son? This is not a religious. Inheritance, maintenance, divorce and marriage, these are no. How you will perform namaz, puja, gurbani, or you will go to synagogue, Jews temple or fire altar temple for Parsis, that is a religious matter. Inheritance is not. So there is a necessity to isolate the personal religious beliefs from these areas which have nothing to do with religion, because land property has nothing to do with religion. ये कोर्ट ने कहा. Getting my point? So ये सारे cases हैं. Let's see here. So Lex Lossy report, this has many time पे prelims में पूछा है कि यूनिफॉर्म इन्हें रिकमेंड किया था evidences and contact मुस्लिम हिंदू पर्सन लॉ को नहीं किया BN Rao committee, he was very instrumental advisor to constituent assembly. Special marriage act है, can two Hindus marry under special marriage act? Yes, I've told you Hindus be marry, anybody who is willing to give up personal law can marry under special marriage act. एक और बात right to marriage पे 2019 या 20 में यूपीएससी हैज आस्क्ड द क्वेश्चन शफी जहां केस हदिया केस में कि राइट टू मैरी समवन इज प्रोटेक्टेड अंडर विच आर्टिकल ऑफ द कॉन्स्टिट्यूशन, आर्टिकल 21 ऑफ द कॉन्स्टिट्यूशन. सो देयर इज अ वास्ट कंफ्यूजन अमंग द स्टूडेंट्स कि ये यूपीएससी ने सुप्रीम कोर्ट ने रूल किया है कि राइट टू मैरी समवन इज प्रोटेक्टेड अंडर आर्टिकल 21 और ये क्वेश्चन आया है प्रीलिम्स में कि राइट टू मैरी समवन इज प्रोटेक्टेड अंडर विच आर्टिकल ऑफ द कॉन्स्टिट्यूशन. 5 year बैक प्रीलिम्स का क्वेश्चन है, आंसर इज आर्टिकल 21. सो इन हदिया केस सुप्रीम कोर्ट सेज राइट टू मैरी समवन इज प्रोटेक्टेड अंडर आर्टिकल 21. इन सुप्रियो केस सुप्रीम कोर्ट सेज राइट टू मैरी इज नॉट प्रोटेक्टेड अंडर आर्टिकल 21. इट इज टू डिफरेंट जजमेंट, यू नीड टू अंडरस्टैंड. पहला, हदिया केस सुप्रीम कोर्ट सेड right to marry someone is protected under article 21. What is permitted by law? For example, any human being wants to marry this bottle, so right to marry someone under article 21 is protected by law. If so, law doesn't allow you to marry this bottle, so right to marry someone is protected under article 21 if the law allows the same. Special marriage act, Hindu marriage act, or personal laws, or Parsi or Christian laws, Christian marriage act. और अभी सुप्रीम कोर्ट ने 5 year बैक कहा था राइट टू मैरी समवन इज प्रोटेक्टेड अंडर आर्टिकल 21 इफ इट इज सैंक्टिफाइड बाय लॉ. अभी कहा सेम सेक्स कपल मैरिज वी विल नॉट अलाउ बिकॉज इट इज अ मैटर ऑफ लेजिस्लेचर, नॉट ऑफ executive, yeah, not of judiciary. I don't want to go, it is a very interesting topic. I've read a lot in the morning also, I discussed in a foundation batch, but I don't want to go. So दोनों में अंतर है. सुप्रियो केस में कोर्ट ने कहा, जो कल रिजेक्ट किया रिव्यू पिटिशन अंडर आर्टिकल 137, कि भैया यू कैन मैरी समवन दैट इज प्रोटेक्टेड अंडर आर्टिकल 21 as long as it is permitted by law. Since marriage between two people of the same sex is not permitted by law, then it will not be allowed. So दो अलग जजमेंट है. Right to marry someone is protected under article 21, true. Right to marry someone of the same sex is not permitted by law, so it is not protected under article 21. कल अगर कोर्ट अलाउ करेगा, ये legislature will allow, then you can marry. One last thing, lesbian, gay, bisexual, transgenders and queer. The difference between WhatsApp University and IASA, Indian Administrative Service aspirant, is different. आप ऐसे नहीं बोलेंगे, कुछ भी LGBTQ बोल के आगे निकल गए, ठीक है? So you must know the difference. Lesbian, same sex couples, you know, but that is homosexuality, a sort of. Then you have gay. Then you have lesbian, gay, bisexual. Bisexual मतलब a person who is heterosexual as well as homosexual. Bisexual. So ये तीनों biological things नहीं है. Being a lesbian, being a gay or being a bisexual is just your orientation. Transgender क्या है? XX chromosome होता है और XY. XX you know, and XY male and XX is female. होता क्या है? up to 6 weeks fetus में sex determine नहीं होता है. After the 6th week एक extra chromosome आ जाता है. Then it becomes XYX. और एक्स वाई वाई, उससे क्या होता है कि फिजिकल उसमें दो फीचर्स होंगे, या तो इट इज मेल बट द रिप्रोडक्टिव ऑर्गन विल बी फीमेल, और इट इज फीमेल बट द रिप्रोडक्टिव ऑर्गन वुड बी मेल. मेनी टाइम्स इट इज नॉट डेवलप्ड. दीज आर कॉल्ड ट्रांसजेंडर्स. ट्रांसजेंडर मतलब ट्रांसफर, ट्रांसजेंडर, ट्रांसलूसेंट, ट्रांसपेरेंसी. ट्रांस मतलब एक से दूसरा. So बीच में from male to female, so transgender is a biological distinction, not a sociological distinction, while others are your orientation. Queer कहा जाता है, एक queer का मतलब होता है एक umbrella term. Queer is an umbrella term for entire community, lesbian, gay, bisexual, transgenders. QUEER is an umbrella term. So you have transgenders, which is a biological distinction, and then you have lesbian, gay, homosexual and bisexual who are oriented. Constitution, the law allows heterosexual marriages, doesn't allow homosexual marriages. That is not protected under article 21. अब यूनिफॉर्म सिविल कोड वही बातें जो मैंने कही है, same thing. Okay, so act now, places of worship act, this you keep a track on this. In the break also I was reading. Okay, so places of worship act में वही the 2-4 major provisions है. Other than the dispute that was already going on, all those places on 15th August 1947, the religious characteristic will not be changed. Recently Supreme Court has put a stay notice. Most likely they don't ask controversial questions, but if they ask, you have a very basic thing: religious character of a place, no person shall convert. जो 15 अगस्त को था वही रहेगा. Ayodhya dispute was kept outside this purview. Now this law has been challenged in the Supreme Court. Let's wait. What they can ask, the secular characteristic of India, that is the thing, and they can ask the difference between Article 25 individual right and Article 26 collective right, the idea of secularism, the secularism between the West and the East, how they may ask about the religious congregation and all such thing. Okay, all such thing. Now preventive detention, last year question आया है, you know preventive detention, punitive detention and preventive detention. 557 preventive detention में, dear students please understand. सबसे पहले let's understand Article 22 of the Constitution, ऐसे ही लिखा है. सबसे पहले clause 1, any person who is arrested and detained shall be placed before the nearest magistrate within 24 hours excluding the time of journey. Excluding the time of journey, and shall be informed of arrest and shall be allowed to consult legal practitioner of his choice. गौर से सुनिए, मैं 22 का पूरा framework और सारे fact बता दे रहा हूँ. Then there will be hardly any question which will. Last year was a tough question on Prevention of Terrorism Act. Second statement was brutally tough because you were not, many of you were not born when that law was passed. So that was a tough question. Otherwise, you see, सबसे पहले Article 22 कहता है, this is the any person who is arrested and detained. What is the difference between arrest and detention? Arrest, एक केस में सुप्रीम कोर्ट ने कहा arrest has an element of touch, पहला. दूसरा, arrest is a smaller subset of detention. For example, there is a murder at Old Rajendra Nagar and you police call that we want you to be at 10 a.m. आप 10 बजे कल आ जाइएगा थाना, we need to ask you something. You go there, then you cannot go, okay, I'm going, I will want to have chole bhature. No, you have to sit there. Your liberty has been confined, but you have not been arrested. In the evening, many times you see in newspaper, the police ED questioned an official for 8 hours. In the evening, the official was arrested. So when your liberty is curtailed, you are under detention. Then it may proceed with arrest. एक केस मैंने पढ़ा कॉलेज में, सुप्रीम कोर्ट ने कहा था, arrest also has an element of touch. जरूरी नहीं है कि detention में will touch you, they will ask you, they will confine you, but arrest में they will touch you, and there is an element of anyways. So any person who is arrested shall be produced before nearest magistrate within 24 hours excluding the time of journey. He or she will be informed the ground of arrest and shall be allowed to consult legal practitioner of his choice. फिर कहता है कि nothing in clause 1 and clause 2 shall apply to a person who is an enemy, alien, who is detained under a preventive detention law. So ये जो safeguard है, constitutional safeguard है, that you will be informed the ground of arrest, you will be produced before magistrate. अब यहाँ book में लिखा हुआ है including the time of journey, but in the constitution it is written excluding the time of journey. Somewhere there is a printing error, minute. Okay. Inform the ground of arrest, allowed to consult a legal practitioner of his choice. फिर कहता है nothing in clause 1 and clause 2 shall apply to a person who is an enemy alien. मतलब ये वाला enjoyment उनको नहीं होगा जो enemy alien है, मतलब citizen of a country with whom India is at war, or a person who is detained under a preventive detention law. फिर कहता है no person shall be detained in preventive detention beyond 3 months. 3 महीने से ज्यादा किसी को preventive detention में नहीं रख, unless an advisory board confirms the same. यानी 3 महीने से ज्यादा डिटेंशन में नहीं रखा जाएगा. 3 महीना खत्म होने से पहले आपको एडवाइजरी बोर्ड की इजाजत लेनी पड़ेगी. You will not be kept under detention beyond the 3 months period. Before the expiry of 3 months period, a permission should be taken from advisory board. Getting my point? No person shall be put under preventive detention beyond the period of 3 months unless an advisory board approves the same before the expiry of said period. So you have to get it confirmed by the advisory board before the expiry of 3 months period. फिर कहता है an advisory board shall consist of person who have been or what you call who are qualified to be judge of high court. यानी एडवाइजरी, अब इसमें भी बुक में थोड़ा मिस्टेक है, दे आर लिखन सिटिंग जजेस ऑफ हाई कोर्ट. कॉन्स्टिट्यूशन में कह रहा है हु विल बी मेंबर ऑफ एडवाइजरी बोर्ड, अ पर्सन हु आर मतलब सिटिंग जज ऑफ हाई कोर्ट, हु हैव बीन मतलब रिटायर्ड जज ऑफ हाई कोर्ट, थर्ड हु इज क्वालिफाइड टू बी जज ऑफ हाई कोर्ट. अंडर आर्टिकल 217 ऑफ द कॉन्स्टिट्यूशन हु इज क्वालिफाइड टू बी अ जज ऑफ हाई कोर्ट शुड बी अ सिटीजन ऑफ इंडिया. उसके बाद शुड बी एन एडवोकेट फॉर 10 years or judicial office in the territory of India for 10 years. They both can be judge of High Court. So even an advocate who is 10 years practice in High Court can also be a member of advisory board. Constitution कहता है who have been or who are qualified to be judge of High Court. हो गया. फिर कहता है no person shall be detained beyond the parliament को power है कि parliament can prescribe the maximum period of detention and under what circumstances a person can be put in detention without the approval of advisory board. These all can be determined by the parliament. अब आगे आते हैं. A person under preventive detention, he will be allowed to make a representation against the said order as soon as possible. उनको भी preventive detention को challenge करने का मौका दिया जाएगा as soon as possible. Make a, ये लिखा हुआ है, make a representation against the order as soon as possible. फिर कहता है, a person under preventive detention will be announced, will be informed the ground of detention. Constitution लिखा है, उनको बताया जाएगा कि उनको क्यों detain किया जा रहा है. फिर कहता है, unless it is against public interest. So a person who is under preventive detention will not be informed the ground of his detention if the same is against public interest. So two constitutional safeguards are also provided to those people who are under preventive detention. Pehla, he will be allowed to make a representation against the said order as soon as possible. He will also be informed the ground of detention. फिर लिखता है unless it is against public interest. अब गौर से सुनिए. प्रिवेंटिव डिटेंशन लॉज का कॉन्स्टिट्यूशन में सीधा प्रोविजन है यूनियन लिस्ट में और कॉन्करेंट लिस्ट में. I have shown you, I think, yesterday. Union list में external affairs, defense, security of state in India and all these matters. अगर किसी इंसान का external affairs और defense के लिए preventive detention, then it will be done by the law will be passed by the parliament. गौर से सुनिए. Preventive detention laws can be passed by parliament as well as. ये क्वेश्चन कई बार आया है. Preventive detention laws can be passed by parliament as well as state legislature. If a person is being put under preventive detention for external affairs, defense of India, security, then the law will be made by parliament. If the person is being put under preventive detention for public order, security of state, वगैरह, then law can be made by both parliament and state legislature. Always remember, public order falls in the state list, but preventive detention of public order is in concurrent list. Public order is in state list, but preventive detention related to public order is in concurrent list, not in state list. Go and download 7th schedule. Concurrent list में you will locate the entry. So ये question आता है चिंटू question. Preventive detention laws can be made by both parliament and state legislature. अब इसका सारा example देते हैं. National Security Act, National, I think section 13 एक साल. Then you have narcotics, drugs and psychotropic substances as section 36 4A है. So एक लॉ है जो ज्यादा मतलब वो टाइट है थोड़ा, दैट इज जेके पब्लिक सेफ्टी एक्ट, जम्मू एंड कश्मीर पब्लिक सेफ्टी एक्ट. मैक्सिमम पीरियड अंडर सर्टेन सर्कमस्टांसेस इज 3 years. सो आई गिव यू 2 examples ऑफ यूनियन लॉ, नेशनल सिक्योरिटी एक्ट, AK रॉय कोस, एंड व्हाट यू कॉल दिस नेशनल सिक्योरिटी एक्ट एंड नार्कोटिक्स, ड्रग्स एंड साइकोट्रोपिक सब्सटेंसेज एक्ट. और एक स्टेट लॉ मैंने बताया जो अब यूटी है, जेके पब्लिक सेफ्टी एक्ट. इसमें लास्ट ईयर का एक केस है, अमीना बेगम केस. एक चेन स्नैचर था, देयर वाज अ चेन स्नैचर. ही वाज पुट अंडर प्रिवेंटिव डिटेंशन बिकॉज ही विल कम आउट, ही विल अगेन snatch the chain. Supreme Court say preventive detention cannot be used for ordinary things like chain snatching. This is a special thing, use it very very sparingly and exercise in a judicious manner. This is preventive detention. Sardar Patel ji, Iron Man of India, writes in his book, when the first preventive detention law was being passed, he was Home Minister of India. He writes that I had 3 sleepless nights. I had 3 sleepless nights. So preventive detention is so draconian, people can be put in jail. If you will ask a Western scholar, so many good things are there in Indian fundamental right. Biggest criticism of Indian fundamental right is Article 22 and Article 34, क्योंकि no major constitution of the world having preventive detention in their fundamental rights. इसमें एक्चुअली आप एनएसए में सेक्शन 13 में 1 साल तक बिना किसी ट्रायल मजिस्ट्रेट के सामने कुछ भी किए बिना आप उसको बंद. So preventive detention should be used in a very judicious manner. Recently भी कोर्ट ने कहा है एंड कमिटीज, हाँ AK रॉय केस में चैलेंज किया गया था नेशनल सिक्योरिटी एक्ट को, सुप्रीम कोर्ट ने कहा बिल्कुल नहीं. द प्रोविजंस ऑफ प्रिवेंटिव डिटेंशन इन NSA इज वैलिड बिकॉज इट इज सैंक्टिफाइड बाय आर्टिकल 22 ऑफ द कॉन्स्टिट्यूशन. वन लास्ट थिंग, प्रिवेंटिव डिटेंशन एंट्री कैन बी फाइंड इन यूनियन लिस्ट एज वेल एज फिर स्टेट एज वेल एज concurrent list. Okay, so we have Attention, ये सुप्रीम कोर्ट ने, ये शाजी केस है रिसेंट का, सुप्रीम कोर्ट हाईलाइटेड द डिटेन्ड पर्सन टू मेक इफेक्टिव रिप्रेजेंटेशन विदाउट ट्रायल, आर्टिकल 22 क्लॉज 1, राइट टू बी इन्फॉर्म्ड मजिस्ट्रेट विद इन 24 आवर्स, ऑल सच थिंग्स। ओके, नेशनल सिक्योरिटी, हाँ इसमें भी ये कॉन्जर्वेशन, ये भी आई से दिस एक्ट ऑल्सो कम्स अंडर द जुरिसडिक्शन ऑफ ईडी, यू कैन सी ग्राउंड फॉर AK गोपालन केस, यू नो, एंड देन यू हैव शिवबन लाल केस, सुप्रीम कोर्ट स्टेटेड दैट कोर्ट रूम में, देखिए प्रिवेंटिव डिटेंशन में किसी को अरेस्ट किया, ही गोज टू द court says this is a very subjective thing, we cannot evaluate inside a courtroom unless there is a pure mala fide. Okay, this is the thing, ये easy। अब सुनिए, अब इसमें भी कुछ चीजें हैं, copyright, trademark, you have intellectual property rights, ठीक है, सब अलग अलग है। geographical indicator, copyright क्या है भाई, सबसे पहले तो patent is given for 20 years, पेटेंट इज गिवन फॉर 20 years। अब आते हैं कॉपीराइट, अब इसमें सब में, अब इसमें यूपीएससी क्वेश्चन पूछेगी, फंसाएगी पक्का, यू विल बी ट्रैप्ड। सो जस्ट रिमेंबर फ्यू बेसिक पॉइंट्स। पेटेंट इज गिवन फॉर 20 years, पेटेंट इज गिवन फॉर 20 years। कॉपीराइट का भी दो फॉर्म है, अगर मैंने कोई किताब लिखी, इफ आई रोट अ बुक और एनी एडवर्टीजमेंट, एनी सच थिंग, इट विल बी वैलिड फॉर माई लाइफ एंड 60 years आफ्टर माई डेथ, यानी आई विल हैव राइट ओवर इट माई लाइफ एंड 60 years आफ्टर डेथ। अगर वीडियो फॉर्म में कोई है, कोई मूवी बनाई 60, DDLJ विल बी ओपन आफ्टर 60 years। सो अब आज सबसे पहले मैंने बताया आपको सबसे पहले आई टोल्ड यू अबाउट पेटेंट इज फॉर 20 years। कॉपीराइट में यू हैव, अगर किताब उताब लिखे, प्ले लिखे, कोई इस तरह शॉर्ट स्टोरी लिखे, तो इट इज वैलिड फॉर 60 माई लाइफ एंड आफ्टर माई डेथ 60 years। अगर मूवी बनाए तो 60 years। अब थर्ड पॉइंट, ये तो सेकंड हो गया, थर्ड हो गया ट्रेडमार्क इज वैलिड ओनली फॉर व्हाट, इट इज वैलिड फॉर एवर, इट इज वैलिड फॉर एवर, इट हैज टू व्हाट यू से विजन आईएएस का अपना ट्रेड मार्क है। सो ट्रेडमार्क इज फॉर एवर, पेटेंट इज फॉर 20 years, copyright if it is book and all, it is for my life and 60 years, movie and all, it is for 60 years। और भी है इसमें, देन यू हैव IT सर्किट और बहुत से अलग अलग प्रोविजंस हैं उसमें रिलेटेड टू, देयर इज अ प्रोविजन रिलेटेड टू प्लांट वेराइटीज एंड ऑल। इन जनरल यू, सबसे पहले इंटेलेक्चुअल कोई भी चीज होती है, दैट इज इंटेलेक्चुअल प्रॉपर्टी राइट, एक जेनरिक टर्म है, उसके अंदर कॉपीराइट मिलती है मूवीज की, ऑल सच थिंग की। मूवीज ऑल्सो गाइडेड बाय सिनेमेटोग्राफ एक्ट, उसमें भी चेंज हुआ है 2 साल पहले, परपेचुअल वैलिडिटी सर्टिफिकेट इज गिवन, सो दैट इज कवर्ड। पेटेंट इज गिवन फॉर 20 years, यू नो कंपल्सरी लाइसेंसिंग एंड ऑल सच थिंग। और ट्रेडमार्क इज फॉर, हाँ ट्रेड सीक्रेट इज ऑल्सो फॉर एवर, ट्रेड सीक्रेट इज ऑल्सो फॉर एवर, ऑल सच थिंग्स आर देयर। ओके, अब ये पर्सनैलिटी राइट क्या है भाई, कि जैसे व्हेन यू विल पे इन फोन पे, तो दे से धन्यवाद दोस्तों फॉर 20 rupees। सो many a time they use a particular person without taking his permission, or in any saloon you will see they have pasted the picture of Virat Kohli without taking his permission। इसको लेके ये मैटर है। आई विल रिकमेंड कि यूपीएससी इस तरह के क्वेश्चन बहुत पूछ रहा है, थोड़ा सा पढ़ लीजिएगा, जोग्राफिकल इंडिकेटर, ट्रेडमार्क, यू हैव कॉपीराइट एक्ट 1957 चेंजेस, व्हाटएवर, ट्रेडमार्क क्या है, कॉपीराइट क्या है, पेटेंट क्या है, इंटेलेक्चुअल प्रॉपर्टी क्या है, बेसिक पढ़िए। ओके, दैट यू शुड नो। दिल्ली हाई कोर्ट ने कहा कि बिना परमिशन के यू कैन नॉट यूज एनी पर्सन हिज पर्सनालिटी ऑल्सो, राइट टू पब्लिसिटी प्रोटेक्ट्स वंस इमेज, ट्रेडमार्क एक्ट, ट्रेडमार्क एंड कॉपीराइट तो यू नो, ट्रेडमार्क एक्ट 1999 जो विजन आईएएस का ट्रेड मार्क है। नाइकी का कैसे ऐसे करेगा, दे विल नॉट राइट नाइकी, बस दे विल डू, एवरीवन नोज दैट दैट इज नाइकी, और एडिडास का एबीबास भी बना देता है। ओके, so okay, now it is protected under article 21 case right to now improper use of emblem, ये तो बिल्कुल सही है, किसी को भी देखिए अपना पहले ही आईएएस बनने से पहले ही एकदम IAS A है, इंडियन एडमिनिस्ट्रेटिव सर्विस एस्पिरेंट। ओके, सो डिफेमेशन, so emblem prevention of so हाँ, this is Rome convention। okay, ऐसे 4 conventions। okay, there are 2-3 conventions। okay, I studied, honestly speaking I studied in law, I'm just missing on that point। Rome convention is related to the performance rights, phonogram, there is 2 more convention। okay, Paris convention भी एक और। what are the various conventions related to various ये देख लीजिएगा, देख may ask this year। okay, so this is TRIPS and all, so you know these are easy ones। okay, some cases are there, UPSC in prelims usually doesn't ask cases, CDS में they have asked cases। I always say कि when you are appearing for prelims, compulsorily you should go through the paper of CDS and CA PF also, pattern by and large remains same। okay, So Enemy Property Act, any Pakistan and China, they have for example, there is a property of a person who migrated to Pakistan. Then his ancestors cannot claim over that. So Enemy Property Act defined an enemy as the country committed external aggression against India. Enemy property was managed. There is a custodian of enemy property. Right to be forgotten, you know. What is right to be forgotten? For example, there is video about you in a public. Okay, you want to remove that. You want to remove that video. So right to be forgotten. For example, you were performing. You performed in your school, and while performing, you were having a lot of embarrassment. That video is still available at you. Now you want that video to be removed. A major demand is going on in the world that there should be right to be forgotten. What is right to be forgotten? When I search your name, any information that comes about you, many a time some information may be uncomfortable to you. So you have a right to erase all the data related to you. Second point. Third, Digital Personal Data Protection Act में there is no specific mandate on right to be forgotten, although intermediary action and all है. सुप्रीम कोर्ट ने केस पुट्टा स्वामी केस में कहा था देयर इज फंडामेंटल राइट टू बी फॉरगॉटन इज अ पार्ट ऑफ राइट टू प्रिवेसी. बहुत ग्रोइंग डिमांड है इंडिया में कि राइट टू बी फॉरगॉटन आना चाहिए. एनी इन्फॉर्मेशन अबाउट यू इन पब्लिक मिल यू मेनी अ टाइम. फॉर एग्जांपल somebody who was performing in a college function in a very bad way, that video is still available. Whenever what you call anybody says, you open that video and show him. So the point is, so it is violation of his. So right to be forgotten is something which is demand. उसका कुछ है doctrine of proportionality, बहुत सारी चीजें. पहला, they will not ask information more than what is required. For example, you are opening an account on a social media site and they are asking that do you like veg or non-veg. So it has nothing to, that information has nothing, they will ask your age so that they know that you are 18 plus and not. Getting my point for the content wise. So unnecessary information. दूसरा, after the use information should be deleted. Getting my information should be deleted. So only that information that is that is necessary. So right to be forgotten मतलब अब इसमें they are saying Supreme Court will examine the right to, sooner or later ये आना ही है. For example, there is a person who said that something he did in college and some information was pasted on internet. The moment somebody puts his name, something of more than 10 years is on internet, that is causing him a lot of embarrassment. So that should be removed, but it should be balanced with freedom of speech and expression, because free flow of information is also necessary. You're getting my point? Okay. So right to be forgotten is not an absolute right, क्योंकि बहुत सारी information public milieu में होगी. Article 129 and 215. Article 129, Supreme Court is a court of record. Article 215, High Court is a court of record. Any court that is a court of record, their judgment is open for everyone. So something bad, actually this happened, a women moved court. There was a divorce case going on between a couple where the husband made certain allegations which were not substantiated. Whatever, we don't know the facts of the case. कुछ divorce case में तो of course some allegations will be made. Later on the women moved the court कि ये information ओपन से हटाइए क्योंकि इससे उनकी इमेज को डैमेज हो रहा है. सो इसी से क्वेश्चन उठा राइट टू बी फॉरगॉटन. अभी इसमें कोई एब्सोल्यूट जजमेंट नहीं है, पर इन जनरल देयर शुड बी अ बैलेंस एक्चुअली नॉट फॉर द सेक हर चीज में वी से देयर शुड बी अ बैलेंस. एक्चुअली देयर शुड बी अ बैलेंस. क्यों? क्योंकि हमारे आवर टीचर टॉट अस यू हैव अ फंडामेंटल राइट टू से एंड यू ऑल्सो हैव अ फंडामेंटल राइट टू से व्हाट अदर्स हैव सेड. So if you hear something from me, you can say to others also. That is also included in fundamental right. So right to be forgotten, if it will be strictly implemented, then freedom of speech and expression shall be but. एक छोटा सा example देंगे, बात खत्म. Tomorrow I will say prepare a lecture on India for Netherlands relations, but you are not allowed to touch internet or any book. So whatever I said in the class, I have been reading for years. So I am not saying what I have said. I am saying what others have said. So freedom of speech and expression is of no value without accessing information. बोलिएगा ही क्या जब तक आप कुछ access नहीं कीजिएगा. So आप whatever you say it from what others have. Oh, we have crossed the time. Okay. So that is something which is there. This we will see. Inner line permit. Inner line permit गौर से सुनिए. Under Article 19(1) D and E, दो ground पे restrict किया जा सकता है. That is in the interest of scheduled tribe or general public. Inner line permit under Bengal Eastern Frontier Regulation 1873. Inner line permit is an inward travel document required by Indian citizens to travel to those areas. Always remember, inner line permit is not applicable to foreigners. Foreigners के लिए है foreigners protected area order. It has all the things that are in inner line and certain more things you need to. जैसे आप घूमने जाइएगा लक्षद्वीप या अरुणाचल प्रदेश, you online you have to apply. They will send you an inner line permit. Those areas where they'll give you for 15 days. So recently it was implemented in Nagaland. It is an inward travel document, allows that Indian. First, what UPSC can ask, the distinction between inner line permit and protected area permit. Inner line permit is only for Indian citizen. Protected area permit is for foreign national. Inner line permit has less areas. Protected area permit has vast area. Inner line permit is a document that you need to visit those areas. Protected area permit is also, but it is usually given to foreigners. They are not allowed to visit those areas. So this is given over here, which all states and all those things. So we will start with fiscal federalism, although we are running short of time. Let's see what we can do. So next class we are coming, we are doing fiscal federalism. If you have any question, genuinely, if I can be of any help in your prelims, you please ask me and you can definitely come. Okay.